Today's our forms day. So we have that kind of to look forward. We're going to go through our forms. And then of course, before we leave today, we'll talk about what Wednesday is going to look like. Getting you guys ready for that test. So we left each other last week and we were in the throes of our offer to purchase and contract. So what questions do I have about anything that we've talked about so far in the contract? We spent the first couple pages defining things, terms and definitions. We went on to talk about fixtures and personal property. Remember, you guys, a fixture is meant to stay. Personal property is meant to go. That's their intentions, right? Fixtures are going to stay. Personal property is going to go. If they're going to do the opposite of their intent, then we need to put them in our offer to purchase and contract. So if a fixture is going to go or personal property is going to stay, that's what we need to list in our contract. We also started talking about our buyer's due diligence. So we'll talk about this in just a second, but I just wanted to go back real good. Make sure we're real quick, I should say, and make sure we're good on, good morning. Make sure we're good on, the various things of the contract that might be a little bit different. So buyer goes under contract. They put down, they're going to have them write 2 checks right away. Congratulations, buyer, you're under contract. I need you to give me 2 checks. One is the earnest money that's made out to the escrow agent. The other one is the due diligence fee that's made out to the seller. Okay. What the buyer's paying the seller for, that due diligence fee, they're paying for the right to terminate. And the contract specifically says the right to terminate for any reason or for no reason at all. So maybe they find a really good reason. Maybe they just wake up and change their mind. But that is what they're paying for, is that right to terminate. If they terminate within due diligence, they have exercised their right to terminate. The seller will keep the due diligence fee and the buyer will get their earnest money back. Can the seller sue the buyer for terminating? Can the seller sue the buyer for terminating during due diligence? You can shake your head one way or another. Can they sue? No, because that's what they paid for, right? Is that right to terminate. The seller accepted that money knowing that they have that right to terminate for any reason or no reason. If the buyer terminates after due diligence for any reason, and I think the one that's the hardest for us to understand, and that includes failure to get loan approval. So after due diligence, if the buyer terminates for any reason, now they are in breach. The seller will still keep the due diligence. Now the seller will get the earnest money. We'll talk more about those remedies when we get to our termination paragraph or remedy paragraph later in the contract. So the due diligence, again, is the buyer's right to terminate. The earnest money, just think of earnest money as the buyer's good faith. The seller wants to know that this is a serious buyer. The seller wants to know that they're not just out there kicking tires. They want to know, because think about this. Doesn't the seller have their own thing they got to do? They got to find somewhere else to live, right? So maybe they are signing maybe they're signing a lease, maybe they're buying a house, but the seller's got to make arrangements. So we want to make sure, listing agents, make sure that when that offer comes in, the due diligence and the earnest money is adequate for the seller. If the buyer walks away the day of settlement, if the buyer never shows up, the seller needs to be sure that they're good with those amounts, because that's all they get. That's it, due diligence and earnest money. We talked a little bit about this market. Right now, this market, earnest money and due diligence amounts are crazy. They're very, very high right now. But we're going to start seeing a shift. We're going to start seeing those numbers come down. I remember a time in the last buyer's market where buyers were offering $50 a due diligence and $50 in earnest money. So we just need to make sure we know who we represent and make sure that they're best represented. What comments? Do you guys have thoughts on that earnest money or due diligence? So where we are in our contract, we've talked about fixtures, personal properties. We're kind of in the throes of talking about the buyer's due diligence process. And I think I made the comment the other day, when you're looking at standard form 2T, when you're looking at your contract, provisions 4, 5, and 6 are all about the buyer. So if you're a buyer's agent, if you're working with that buyer, then these are the ones that, the whole thing's important, of course, but we know they're not going to read this thing. So maybe if we can help point them in the direction of the important pieces. So if you're working with the buyer, I would definitely point them to provisions 4, 5, and 6. Particularly provision 4 is the buyer's due diligence. So we looked at our big red warning here the other day. Buyers strongly encouraged to conduct all their due diligence during the due diligence period. The buyer can ask the seller to grant an extension. We can ask for more time. Does the seller have to grant that extension? Do they have to give more time? No, it tells us right here, they're not obligated to grant an extension. Buyer's agents, when you're writing up this offer to begin with, we need to make sure that we're asking for enough time going into it. And I understand things happen, things get delayed, things come up. I get all that. But we need to make sure we're asking for enough time going into it, understanding there's no requirement whatsoever on the seller to extend that. Again, this market's really changed things. We get back to a buyer's market. Think about this market. The seller goes under contract and within a day or two, they have 20 buyers standing in the front yard with an offer in their hand, So if this buyer terminates, whoop-de-doo, I got 19 other that want to buy, right? That pendulum's going to swing back, you guys. Sellers may be on the market for 5 months, 6 months, 8 months, 9 months, a year and a half. They may be for sale for a long time before they get a decent offer. So when that happens, if we're on the market for 9 months and a decent offer comes in, isn't the seller going to be more apt to grant an extension or do a repair because they fear that buyer walking away and having to wait, 9 more months before the next one comes along? So it's absolutely dependent on the market. Then we left and we were just talking about the various things that the buyer should do during their due diligence. And number one, the thing that's going to take them the longest is getting that loan approval. So buyer's agents, remember, as soon as we go under contract, do your little mini celebration, but then you want to go ahead and get that signed contract to the lender so they can start their thing. We need to do that today so they can start their thing. And remember the gears that we looked at, the working gears, and we said if any of those gears stop, the whole thing stops. I think keeping the buyer and lender in communication is one of the things that we can do to keep those gears going. Let your buyer know that the lender can't go on with their process. If they're requesting forms, if they're requesting documentation, the buyer needs to get those to the lender stat, because the lender can't move on until they've gotten requested documents. So I think as far as keeping communication open and keeping those gears turning, making sure your buyer's getting the lender what they need. I've had buyers delay their own closing, right? Like, I don't know why, I had one particular buyer, she wasn't a pleasant person. We'll just leave it at that. And yeah, she was like, this whole do it right now thing ain't going to work for me. I'll get it to the lender when I can get it to the lender. And I'm like, all right, don't come crying to me when your closing's delayed. And it was, and she was upset. You got to keep those gears going. She was something. It takes all kinds, doesn't it? The last thing we talked about, again, in the buyer's due diligence, it gives us a list. The contract gives us a list of things that the buyer should consider doing during their due diligence. Remember, most things aren't required. If the buyer's getting a loan, if the buyer's using a lender, they have to get an appraisal. That the lender requires that. If it's a cash buyer, the appraisal is optional. If it's a VA buyer, they probably have to get a pest inspection, a wood destroying insect inspection. If it's FHA or conventional, it's probably, I just recommend it. So, you know, certain things that the buyer should consider understanding. They may or may not do these things. They may want to do more. And I think the last thing we said the other day, I actually try to keep things simple in life. I don't know about you guys, but I like things simplified. And my pretty simple philosophy when I'm working with buyers is, if it's important to my buyer, then it's important to me. So if my buyer says, I want to inspect this or investigate that, my answer is going to be, okie doke, let's do it. We're never going to look at our buyer and say, well, it's not on page 4 of the contract, so we don't have to. You guys with me? If it's important to them, if they want to learn about it, they are the ones buying this house. So that officially gets us through to where we ended on whenever we met last week. I guess it would have been Wednesday. I don't know, my days are all off. Whenever I saw you ladies last, that was the last thing that we talked about. So any questions or comments about anything thus far?
Julie, just one thing.
Yes, ma'am.
I just want to make sure I'm clear.
Mhm.
Doing the due diligence, if the buyer cancels, the seller keeps the due diligence,
Correct.
but the earnest money goes back to the buyer.
That's it.
After due diligence and the buyer cancels, the seller keeps due diligence and earnest money.
She's got it. Absolutely.
Okay.
Yep,
Thank
you
you.
got it. Vivian, the buyer's not considered in breach until after due diligence. So if they terminate during due diligence, that's why they get their earnest money back. That's their good faith money. That due diligence period, remember what they're paying for is that right to terminate. So if they terminate, they're just doing what they had that right to do, what they paid for. The consequences of the buyer's breach are losing the earnest money. So the due diligence, that's a right to terminate for any reason, at 5:01 that day, they've lost that right to terminate. And now they're going to lose the earnest money. We are going to see, I think in just a minute, we'll see what's we get in the contract when we look at buyers and seller breaches. The due diligence and the earnest money in the event of the buyer breach, that's it. That's the seller's sole exclusive remedy. So again, you know, I think the consequences, no, I don't think. The consequences for seller breach are much harsher than buyer breach. Because let's think this through for a second. Isn't the seller the one that initiated this whole thing to begin with by putting a for sale sign in their front yard? Aren't they the ones that said, hey, bring me an offer? They didn't have to do that. So if the buyer breaches, they lose due diligence and earnest money. We're going to learn in just a minute, if the seller breaches, man, the buyer can go after them for all sorts of things. And we'll talk a little bit more about that. In the event of seller breach, that's going to be about the only time that they lose. There's a couple other examples that we'll get to, but for the most part, unless the seller breaches, they're going to keep that due diligence. Anything else before we continue on? Questions or thoughts? So still talking about our buyer's due diligence, sale or lease of existing property. As noted in paragraph 5B below, which we'll get to it, unless otherwise provided in an addendum, this contract is not conditioned upon the sale or lease or closing of another property owned by the buyer. Therefore, if the buyer must sell or lease other real property in order to qualify for a new loan or to otherwise complete the purchase of the property, buyer should seek to close on buyer's other property prior to the end of the due diligence period, or be reasonably satisfied that closing on buyer's other property will take place prior to the settlement date of this contract. We're going to see in just a second where the buyer has to represent to the seller if they have another property to sell, but there's no contingency. The contingency, big picture of contingency says, if this doesn't happen, then I can't do that. So what we're talking about right now, I can't buy your house if I don't first sell or rent mine. And what we're saying in this paragraph is that there is no contingency. Now, let me ask you guys, can the parties agree to add a contingency? Can we agree to add that contingency? Absolutely, absolutely. But there's nothing automatic. I don't even have a form for a contingent sale addendum anymore. That form retired. You may still see verbiage about that in your book. We'll look at that in just a second so I can tell you guys where to cross it out if you do still see it. But we don't have the contingent sale addendum anymore. So if the two parties want to add the contingency, if they agree to add the contingency, then we have to get an attorney to draft something up. We don't have verbiage for it or form for it anymore.
And then that would be an amendment to the contract, correct?
We could draft it up as an addendum, present it with our offer. If we add it after the fact, then yes, that would be an amendment. Yep. Again, we're not seeing many of these contingencies in this market. 20 offers come in and one has to sell a house before they can buy yours. That one doesn't look real good, does it? The other 19 that don't have a property to sell look better, but that pendulum is going to swing back. And it might be that, again, if the seller's been sitting on the market for a year and a half and the first offer that comes in has a contingency on it, the seller's probably more apt to consider that offer. What are they going to do? Wait another year and a half. So we're going to see some changes. We're going to see some things change. And one day we'll be back in a seller's market again. That pendulum is constantly moving. So sale or lease of existing property, try to close prior to the end of due diligence or be reasonably satisfied that closing on buyer's other property will take place prior to settlement. Kind of a gamble there, kind of a risk. Repair improvement negotiation agreement, buyer acknowledges and understands the following. Unless the parties agree otherwise, here it is. The property is being sold in its current condition. Does the seller have to do any repairs? Do they have to change a light bulb? They don't have to do a thing, do they? Because what's the contract say? The property is being sold in its current condition. If the seller agrees to do one repair, anything, like I said, change the light bulb, we've now amended the contract. So if they agree to do anything whatsoever, remember last week we looked at our due diligence repair and request agreement. That kind of now, once the seller signs that obligates them to do whatever agreed upon repair. They're now contractually obligated to do that repair. But we need an agreement by the seller while we're still in due diligence if they are going to do anything. And then it says seller may, but is not required to engage in negotiations for repairs and improvements to the property. Buyer is advised to make any repair improvements requests in sufficient time to allow negotiations to be concluded prior to the expiration of due diligence. Any agreement that the parties may reach with respect to repairs and improvements is in addition to this contract and must be in writing and signed in accordance with paragraph 19 below that we're going to see. We have a blue note here just referencing us to other places in the contract that we're getting to. But just referencing us to other places in the contract that it talks about these repairs, improvement negotiations, and agreements. Please remember what we said last week. If the seller agrees to do any repairs, they got to be agreed on in writing and signed by the time we're out of due diligence, by 5 p.m. of due diligence. But guys, I think the problem topic is that the repairs themselves don't have to be complete until prior to settlement. So we could sign the form at 4:59 p.m. today if our due diligence is up today. But now the seller has that period of time between due diligence and settlement to actually do the repair that they agreed to do. Does that make sense to everybody? Questions on that?
Okay, maybe I misunderstood because I just
Please.
wrote down any repairs must be completed in the due diligence period. So you're saying,
Mm-mm.
no, it does not have to be
They
completed.
have to be done prior to settlement. We got to have it signed before the end of due diligence. Thank you.
Thank you.
Okay, yeah, thank you. So, yep, we got to have it agreed upon in writing while we're still in, because let's think this through again. Remember, due diligence is the buyer's right to terminate, right? Now knowing what I know, I've got investigations and inspections, and I learned all about this property. And now knowing what I know, do I want to move forward with or terminate this transaction? Well, if me deciding if I want to move forward with or terminate is dependent on the seller doing repairs, if I don't have their agreement to do repairs, then I don't have all the information I need to decide if I want to move forward with or terminate. So the only way I can secure that information to make that decision to proceed or terminate is if I got the seller's signature in writing telling me that, making them liable to do it. And then they have until settlement to actually do it.
Okay, so then as far as the things between the buyer and the seller of the contract, the repairs, if agreed upon and signed in the due diligence time, is about the only thing that can be done prior to this settlement or settlement of the contract. Because appraisal, inspections, buyer qualifying, all that needs to be done in the due diligence time.
That's right.
Okay,
That's right.
just as long as it's amended and added to the contract, the actual repairs being completed is about the only thing that's done by settlement.
Yep. Yep.
So is there a 2 or 3 day lag time that if the buyers wanted to re-inspect the property after the seller said that they've done the repairs? Is there a timeline for that that's in writing somewhere or just a negotiable item?
It's kind of negotiable. It don't have a specific timeline, Patricia. The contract does say that the buyer has the right to verify those completed repairs prior to settlement. So, when prior to settlement are these going to be done? Is it going to be 2 hours? Is it going to be 2 days? Right. But no matter when it's complete prior to settlement, the buyer has the right to go back and verify those agreed upon repairs before they take property.
The amendment would need to state, just so that everybody's clear on the same page, that seller is to complete all negotiated repairs 3 days prior.
By this date or something like that. Yeah, and we could put that when we're making our due diligence repair request.
Yeah.
We could put that as part of that verbiage. We want the electrical fixed by, 2 days prior to settlement, kind of thing. Absolutely make that part of the agreement there. Yep. Great points. And guys, remember what we say.
So for
Yes.
the buyers, are they actually giving pre-approval letters or are they actually giving approval letters for X amount of dollars?
We go under contract with pre-approval. So once we have a contract, then the lenders will start their approval process.
Okay, so do the lenders here then do an actual approval, been through underwriting, done their conditions based upon property to be determined up to a certain amount? Do they go that far?
Not that I'm aware of.
Okay.
Not that I'm aware. As long as we're under their pre-approval amount, we don't have a problem, right? Or if they can prove they have funds to make up the difference, right? But we're going to need to see that difference. But yeah, not that I'm aware of. Usually, and I'll say this, it's awfully rare to have a buyer approved for their loan while we're still in due diligence. It's really, really rare to have final approval. So what we're hoping for is enough due diligence time to get the appraisal back, get the first round. Usually the loan has to go through underwriting. It's not uncommon to go through twice. So once we come out of the first round of underwriting, we've had the appraisal done, we've had the initial set of paperwork gathered, we can come out of underwriting. The lender can give us a pretty good idea if they feel like they're going to get approval or not. And that's usually what we get during due diligence. So based on, or while we're still in due diligence, I should say. So based on the lender's opinion, whether or not the buyer may choose to proceed or terminate. But if it comes out of underwriting and the lender says, this doesn't look good, then that may be a sign to the buyer that they need to terminate. You with me? In all my years, I've ever only known one buyer, one, to get approval while we were still in due diligence. The others are days before settlement. It's a risk.
Okay, but if we focus as agents on encouraging our buyers, if we're representing them, to go ahead and submit paperwork prior to actually engaging in a contract, that would give us a heads up. I mean, that would give us a better idea of who we're representing.
Remember, we talked about our loan application. The 3 pieces are about the people and 3 pieces are about the contract, right? So we can get the people piece so far. We can't start the contract piece, or the property piece, I should say, until we get the contract. So even then, there's only so far we can go, right, in that approval process. We can get the buyers as close as the way through, but until we get a property, until we get a contract, that's when the lender's loan application process starts. Other questions or comments? It's a risk. It's a risk. Guys, as the buyer's agent, this is why we're helping our buyer get through as much as we can. This is why, as a buyer's agent, we're getting that loan process started as soon as we go under contract. This is why, as a buyer's agent, we're going to get our buyers to shop around for insurance. This is why, as a buyer's agent, we're going to help them keep those gears going. We need to know the home inspection survey, that kind of thing, because as a buyer's agent, the worst case scenario, if we have to terminate, let's terminate within due diligence so you can get your buyer their earnest money back. Once they're under contract and committed, that's the absolute best thing I can do for them, is get them their earnest money back. And if I drop the ball and we don't do inspections in time, we don't get the pretty good idea from the lender in time, now the buyer terminates and losing their earnest money. Are they happy with me? Probably not. So that's why it's so important that we keep that going. We may be on the phone with the buyer every day. Did you talk to State Farm today? Did you get the lender what they need today? You know, because we've got to keep that, because nobody wants to terminate. Terminating is not a good day. But as a buyer's agent, if we have to do it, let's do it while we're still in due diligence to get them their earnest money back. Something's better than nothing, yes? Other thoughts or opinions? It's a risk. Some lenders will tell you they just need 3 weeks, 21 days to get through due diligence. You know, some will tell you they need a little bit more. I tell you, every lender is different. So as you guys are starting to work with lenders and get to know lenders, if you're new to this lender, you're writing an offer, just pick up the phone and call them. Be like, hey, we have a client that we are trying to get to closing. How much time do you need? What do you suggest? Let's all work together on this. We shouldn't be working against each other. We're all working for the common goal of getting this buyer to close. All right, so buyer's obligation to repair damage. Buyer shall, at the buyer's expense, promptly repair any damage to the property resulting from any activities of buyer and buyer's agents and contractors. But buyers should not be responsible for any damage caused by acceptable practices, either approved by the North Carolina Home Inspector Licensing Board or applicable to any other North Carolina licensed professional performing reasonable appraisals, tests, surveys, examinations, and inspections of the property. This repair obligation shall survive any termination of this contract. So if the buyer's home inspector, for example, damages the property, maybe they're going up on the roof and they put their ladder and they like gouge a hole in the side of the house. If the buyer's home inspector damages the property, who is on the hook for that? And the contract tells us it is at the buyer's expense. So guys, here's another really good reason. Don't we need to be recommending trustworthy home inspectors? Don't we need to be recommending people that we know will do a good job? This is another good reason to form relationships. Now, with that being said, do mistakes happen? Of course, sometimes even the best home inspector can damage the property, right? But this is where, again, where you and I can help and get a reputable home inspector in there to begin with.
Julie, in that same paragraph, the instance, the inspector goes on the roof, walking across the roof, his leg goes through. That's on the seller, not the buyer,
Mhm.
correct?
The buyer shall, at the buyer's expense, promptly repair any damage resulting from any activities of the buyer's agents and buyer contractors.
But buyer shall not be responsible for any damage caused by accepted practices.
So an example of accepted practices, and I love this example, when you get home inspection reports back, if, for example, there is rotted wood, maybe rotted wood in the door frame or the windowsill, do you know how the home inspector shows that? They take their big screwdriver and they jam it in there, and then they take a picture. They didn't damage it. It was already damaged. That's just them showing you in a picture, look, this wood is soft. If it wasn't, my screwdriver wouldn't stick in there. That's kind of what we refer to as accepted practices.
So the hole
Now,
in the roof,
could this wind up in a lawsuit? Could this wind up in court, Vivian?
Okay.
Absolutely. Absolutely. In your example, if we fall through the roof, the buyer may say, I'm not paying for that. The roof was damaged before my guy got up there. The seller may say, you damaged my roof. So remember, unfortunately, if two parties can't agree to agree, the judge will decide for them. And I think your example, Vivian, is absolutely something that'll send us to court to get this resolved, because now neither party are happy about this, are they? The other piece of this sentence that I think is so important is that this repair obligation shall survive any termination of the contract. So the home inspector damages the property, the buyer terminates. The buyer's still on the hook for fixing that. Just because they terminate the contract isn't a reason not to repair that damage. I had an agent fall through the ceiling once. That turned into a huge legal battle. I don't even remember the outcome of that, but that was exactly it. The buyers were saying, look, if this floor would have been secure to begin with, then my agent wouldn't have fallen through. The sellers are saying, this floor was just fine, you broke it. And I never heard the outcome of that. I don't know where it ever went, but does it happen? Absolutely. I always think of Christmas Vacation with that story. Hopefully there was something like the top of a bunk bed or something that they could fall on if they did fall through the roof. Y'all know what I'm talking about in that movie? That's a great movie. So hopefully there's something to prevent them from falling down and getting hurt, right? Indemnity, if you indemnify somebody, you're just holding them harmless. So again, this is another piece of the contract that could be interpreted per the courts, right? So if we're indemnifying, the buyer will indemnify and hold the seller harmless from all loss, damage, claims, suits, or costs which shall arise out of any contract, agreement, or injury to any person or property as a result of activities of buyer and buyer's agents and contractors relating to the property, except for any loss, damage, claim, suit, or cost arising out of pre-existing conditions of the property and or out of seller's negligence or willful acts or omission. This indemnity shall survive this contract and any termination hereof. I'm going to call that standard boilerplate language. I think most contracts, we see something that says we're going to hold each other harmless unless we have a reason not to. So it's kind of the right to sue is what this has given us, is permission to sue if we need to, but we can't just sue for the sake of suing, right? So we got to have some kind of, we're going to see this exact same paragraph when we look at the sellers in just a second as well. Buyer's right to terminate, provided that buyer has delivered an agreed upon due diligence fee, buyer shall have the right to terminate this contract for any reason or no reason by delivering to seller written notice of the termination during the due diligence period time being of the essence. If buyer timely delivers the termination notice, this contract shall be terminated and the earnest money deposit shall be refunded to the buyer. So it helps us out, tells us right there. If the buyer exercises their right to terminate during due diligence, they will get their earnest money back. The last little piece here I think is very important. They do too. That's why it's in all caps and bold. Closing shall constitute acceptance of this property in its then existing condition unless provisions have been made otherwise in writing. The buyer needs to understand that once they sign for this property, it is theirs. They need to know what this house looks like before they sign. Would everybody agree with that? We're going to talk about the importance of the final walkthrough in just a minute. If buyers don't do the final walkthrough, you guys, how do they know the property in its existing condition? How do they know what they're signing? So the final walkthrough, and I try to do mine as close to settlement as I possibly can, like on our way to the attorney's office. If I can't get the final walkthrough that morning or that day of settlement, then I'm doing it like the night before. I'm trying to get them to see it as close to settlement as we possibly can, so we know that they know what they're signing for. So now the question always comes up, what if you go do the final walkthrough and there's a bunch of trash or there's a bunch of personal property? What if you're doing the final walkthrough and you've never seen this home vacant before? You've only seen this home occupied. And now you're at the final walkthrough hours before settlement, and you see the whole reason that this picture was here was to hide a big hole. If the seller sees something, if the buyer sees something that they don't like in the final walkthrough, if they have a bunch of trash or holes in the wall or whatever, the buyer's got two choices. They either go to the attorney's office and sign accepting the property in its existing condition, or they don't. They have choices. If they're not going to sign, it's not over yet. Remember, we could delay it if need be, but the parties need to get together and figure out, what do they need to do? Does the seller need to go clean the trash out? Do they need to repair holes in the walls? You guys with me? The buyer's not going to be able to sign and then come back and say, I expect the seller to fix this hole in the wall. If they sign, they take the property as it is, and that includes with the trash and the hole in the wall. That's a hard choice sometimes for buyers, right? Another reason why I tell my buyers to always have a plan B. I don't know what the house is going to look like, but I do know they have choices. If they're not happy with the property, its condition, their choice is either you go right now and sign, or we call the listing agent and see what's planned to be done, what's going to be done about this. What questions or comments do I have about that? I had buyers once. When we when we saw the house, it had the pull down stairs in the attic, like in the hall, and the pull down stairs. And of course, my buyer poked his head up there. He wanted to see what was up there. Home inspector, we went under contract. Home inspector poked his head up there, and there was stuff up there, personal property up there, but the people were still living there. So we didn't think anything about it. We just all thought it would be gone before closing. So my buyers and I, this is actually one of my good girlfriends. Her and I met that morning at the house of closing to do her walkthrough. And then her and I were going to go get some breakfast on our way to the attorney's office. We were going to go out and have girls' time and get some breakfast. Her and I were doing the final walkthrough. It had been vacant. The first time we've seen it vacant. So now we're looking at, walls and things, floors that we couldn't see before. Everything looked fine. And on a whim, she said, my husband reminded me to look in the attic. And I said, oh yeah, of course, that's why we're here. She pulled the stairs down. Everything was still up there. All that personal property was still up there. So I called the listing agent and I said, they coming back to get that stuff? And she said, well, it's not their stuff. I said, well, whose stuff is it? Somebody needs to come to get their stuff. Guys, come to find out, all that stuff in the attic was personal property of the previous owner. In the 7 or 8 years they lived in that house, they never poked their head in the attic to know that there was stuff up there. They were shocked. We got it all. No, you didn't. So they had to go back and get it out. I asked my girlfriend, I said, you sure you don't want it? There could be some treasures up there. She said, no, I got my own stuff to worry about. I don't want to deal with somebody else's. So we had them go back and get it.
But Julie, shouldn't that have been maybe on the disclosure, some on the repost that previous owners' stuff was in the attic?
Because when they bought, they accepted the property in its existing condition. So when they got that stuff.
Right, I mean, I understand that, but for this sale with your girl, shouldn't they have disclosed that previous stuff was there?
They didn't know. They never looked in the attic in the 7 or 8 years that they lived there.
So that means they never changed the filter or had the AC check. Okay, never mind.
Or the roof, the AC was in the crawl space. I'll give them that. You know, there were no major components in the attic. But how do they know? How can they tell me that the roof leaks? They don't know. They haven't looked, or doesn't leak. They haven't looked up there in 8 years. They never once, when I said there's stuff up there, them and the agent were shocked. You know, I want the twist to this. The listing agent was also mom, and mom helped them buy that house. So when mom was their buyer's agent, shouldn't mom have suggested that they poke their head in the attic, that they look up there every once in a while? And then what moms do anyways, make sure you check everything. It was it was an unbelievable situation. And they were just shocked. And my friend and I were like, yeah, you got to take care of this, because she doesn't want it. When you bought it, it became yours because you accepted it. Obviously, the former owner never wanted it. They never came back and asked for it. Is that crazy? Y'all look in the attic every once in a while. I know it's not the most pleasant place of your house, crawl space as well, but sometimes things are down there that we need to know about.
So did she sign?
Oh, they had it cleaned out by the time. Yeah, her and I went on a breakfast. They went back to the house and got it all cleared out. Sent us pictures so we could see that it was all cleared out. Yeah, her and I went and had us a nice breakfast. They showed up to settlement all sweaty and stuff because they'd been running up and down getting that stuff out of the attic. Sorry.
So do sellers and buyers close together here?
Our appointments at the same time, but remember, TRID says the two can't be in the room together signing paperwork. So if the seller insists to come to closing, they usually go back and do their thing first. Takes 10-15 minutes, and then they'll go, and then the buyer will go back and do their thing. If my buyers and sellers ever meet, I want it to be at the attorney's office, in the lobby at the attorney's office, while I'm still there, by the way. Other questions or comments? The buyer needs to know what they're signing. That's the bottom line of this last provision, this last sentence here. The buyer needs to know what they're signing, because once they sign, they're accepting it as it is. Stuff in the attic and everything. Number 5 is the buyer representations. These are representations that the buyer's making to the seller. And these need to be accurate. They need to be truthful, because the buyer, the seller should consider these when they're deciding if they want to enter into a contract with this buyer or not. So the first thing that the buyer is going to represent to the seller is any funds that they may need to complete the purchase. We're told to check, if applicable, is it cash? Buyer intends to pay cash in order to purchase the property, does not intend to obtain a loan or funds from sources other than the buyer's own assets. Verification of cash available for settlement is or is not attached. Blue note, if the buyer does not intend to obtain a new loan and or funds from sources other than buyer's own assets, seller is advised prior to signing this offer to obtain documentation from buyer which demonstrates that buyer will be able to close on the property without the necessity of obtaining a loan or funds from sources other than the buyer's own assets. So even though the buyer may not attach a letter, the seller still warned and cautioned, don't sign a contract until you see that proof of funds. Don't see that until you see a letter from the bank. So cash is an option, or check if applicable. The buyer intends to get a new loan or other funds. Buyer intends to obtain a loan and or other funds to purchase the property from the following sources. We're told to check all that apply. So here's information on the first mortgage. They're going to attempt to get FHA or VA. If they do FHA or VA, then we're instructed to attach our FHA VA financing addendum. Remember, the contract tells us when we may need to use certain addenda. It takes the guesswork out of it for us. That FHA VA financing addendum is one that we'll look at later today. Is it conventional, USDA, etc.? Is there going to be a second mortgage? Or is there going to be other funds? I think a good example of other funds, buyer tends to obtain funds from the following sources. There's these down payment assistant programs, for example. So that might be an excuse for a reason for other funds, an example there. Our blue note says buyer's obligation under this contract are not conditioned upon obtaining other loan. That's the second time we've seen that now. Or other funds from sources other than buyer's own assets. Some mortgage loan programs and other programs providing funds for the purchase of the property selected by buyer may impose repair obligations and or additional conditions or costs upon seller or buyer, and more information may be needed. Material changes with respect to funding the purchase of the property that affect the terms are material facts that must be disclosed. So we can't, the inability of our principal to complete the transaction, that's a material fact we need to disclose. Here's our other property. And remember, we're at buyer representation. The buyer's representing to the seller. They do or do not. You guys there? So weird. Okay. Buyer has to represent to the seller that they do or do not have to sell or lease other property in order to qualify for a new loan or to complete the purchase. So we're not creating a contingency here. The buyer's just representing, I do or do not have to sell or lease another property to buy yours. If they do, we're told to complete the following, complete the rest of this section. So we want to know what the other property address is. If applicable, we're going to select that the buyer's other property is under contract as of the date of this offer, and a copy of this contract has either previously been provided to the seller or accompanies this offer. Buyer can mark out any confidential information such as purchase price and their buyer's identity prior to providing a copy. Failure to provide a copy of this contract shall not prevent this offer from becoming a binding contract. However, all caps, seller is strongly encouraged to obtain and review the contract on buyer's property prior to accepting this offer. So the seller's cautioned to get a copy of that in their hands before they accept this offer. Other check if applicable, buyer's other property is not under contract. Buyer's property, then we're told to only check one, either is listed and actively marketed by a real estate broker, will be listed and actively marketed by the real estate broker, or the buyer's attempting to sell on their own. So we're just representing to the buyer, to the seller, that they have to sell a house, but we're not creating a contingency. And to solidify that, our blue note says this contract is not conditioned upon the sale, lease, or closing of buyer's other property. If the parties agree to make this contract conditioned on the sale, lease, or closing of buyer's other property, an appropriate contingency addendum should be drafted by a North Carolina real estate attorney and added to this contract. The contingent sale addendum retired a couple years ago.
This is so wonderful, Julie. That this is part of the contract. It's so wonderful.
That it's just right in there. Yeah, we don't have to, like I said, we're not seeing contingencies in this market when the seller has choices, but it could come back. The buyer's going to be in the driver's seat again one day, and they're going to have the right to say, I want to do this. And what we need to know is we don't have a form. So when this comes back, we're gonna have to get something attorney drafted. Right now, while I'm thinking about it, will you guys turn in your books, your real estate manual to page 354? 354. 354 talks about the contingent sale addendum onto 355 and some of 356. Cross that out. 354, 355, and 356, where it talks about the contingent sale addendum. That form has retired. It is no more. So as Patricia says, in case we forget, our contract says if we're going to create a contingency, then we have to have an addendum drafted by a North Carolina real estate attorney. Comments on that? Still under buyer representation, performance of buyer's financial obligations. To the best of the buyer's knowledge, there are no other circumstances or conditions existing as of the date of this offer that would prohibit buyer from performing buyer's financial obligations in accordance with this contract, except as may be specifically set forth herein. When I read this, you know, if the buyer's like facing bankruptcy, contemplating bankruptcy, if their bankruptcy procedures could prevent them from buying this house, then the seller has a right to know that. They have a right to know that they're in bankruptcy, and depending on the end of this, I may or may not be able to buy your house. So we just need to represent to the seller if we have any other things that could affect our financial obligation. Buyer needs to represent to the seller the receipt of the seller disclosures, particularly the Residential Property and Owners Association Disclosure Addendum and the MOG, Mineral and Oil and Gas Rights. We're going to see the same verbiage for both of these. So the buyer has to select one, check only one. They have received a signed copy of the RPOs prior to making this offer and acknowledge compliance with this North Carolina General Statute. They have not received a signed copy of the RPOs prior to making this offer and shall have the right to terminate without penalty. And that includes a refund of their due diligence fees. I think earlier we talked about when could the buyer get their due diligence back? Well, the biggest reason they could get it back is if the seller's in breach. But they could also get it back if the seller fails to provide their seller disclosures. And guys, keep in mind, the buyer's not acknowledging that they like the way this thing was complete. The seller has the right to say no representation. That's their right. They can if they want to. What the buyer is signing is acknowledging receipt. They're not saying they agree with it. They're not saying that they like it. They're just checking here, acknowledging receipt. Everybody with me? So they have the right to terminate without penalty, which includes a refund of their due diligence fee, whichever the following events occur first. So either looking at the end of the third calendar day following receipt of the disclosure statement, the end of the third calendar day following the effective date is kind of a timeline, which one happens first, right? And that's when our 3-day clock starts, or a settlement or occupancy by the buyer in the case of a sale or exchange. So if the buyer already lives there, maybe it's a tenant doing a rent to own situation. They already live there. They would not have this form, the RPOs or the MOG. Comments on that? I will say here in the Triad MLS, the majority of time, not 100%, but the majority of the time, when you look at a property, when your buyer says, I'm interested in 123 Main Street, and you look at the property, most of the time we already see these forms already uploaded. So there are, I'd say as Triad MLS, I'd say as a whole, we're pretty good about making it available. You may have the rare occasion, I'm not saying 100% accuracy, but you may have the rare occasion where you don't have that form. You just need to get with a listing agent and know that your buyer may have the right to terminate and get their money back if the seller doesn't provide. The third option here is if the RPOS is exempt. We're instructed to see the guidelines. Remember last week we talked about the guidelines to complete the offer to purchase and contract. So the guideline gives us reasons why these forms might be exempt. And for the RPOS, the number one reason is new construction. This form is not required for new construction, never before lived in. And then we go through the very same exercise with the MOG. So I won't, go through that again, but we need to select the buyer has received, the buyer is not received, or they're exempt. See the guidelines. So buyer represents if they received it or not. Buyer's receipt of the MOG does not modify or limit the obligations of the seller under paragraph 8G below, which we're getting to. And shall not constitute the assumption or approval by buyer of any severance of mineral and or gas rights, except as may be assumed or specifically approved by the buyer in writing. Our blue note tells us that the parties are advised to consult with the North Carolina attorney prior to signing this contract if severance of the mineral and or gas rights has occurred. So if the seller has already severed them or intends to sever them, the buyer's advised and the seller to talk to an attorney. It's to my understanding that severance of subsurface rights gets very tricky and legal needs to be brought in to make sure we're all proceeding properly. Comments on the buyer representations, the thing that the buyer is representing to the seller. Then we got the buyer's obligations. What's their responsibility? First off, we start with responsibility for special assessments. Remember, we defined special assessments back in provision 1. Could be put on by the government to improve the land. Maybe they're going to put in street lighting or sidewalks, for example. Special assessments can also be put on by the HOA. So for example, if you have a townhome community, they may have a special assessment to repair the roofs or repave the parking lot. So we've defined them previously, but now under buyer obligations, we're going to say that the buyer shall take title subject to all special assessments that may be approved following settlement. So the buyer's responsibility for special assessments are those that are approved after they buy. Now we got a place where the seller is going to disclose if they know of any that are proposed, any that are on the table for discussion, but the buyer won't be responsible until they buy. We'll talk about the seller's responsibilities for special assessments when we get there. Responsibility for certain costs. Buyers shall be responsible for all costs with respect to, well, there's their loan again, charges by an owner's association, under paragraph below, appraisal, title search, title insurance, fees charged by the closing attorney for preparation of the closing disclosure, seller disclosure, and any other settlement statement, recording the deed, and preparing and recording all instruments required to secure the balance of the purchase price unpaid at settlement. So it spells out the things that the buyer is responsible for. Authorization to disclose. Buyer authorizes the buyer's lender, party's real estate agent, and closing attorney to provide this contract to any appraiser employed by the buyer or their lender, and to release and disclose any buyer's closing disclosure, settlement statement, and or disbursement summary of any information therein to the parties to this transaction, their agent and their lender. Remember, we went under contract. I did my little mini celebration, and then I immediately sent the contract to the lender. I'm also going to send the contract to the attorney, aren't I? Once the lender gets the contract, they order the appraisal, they're going to send the contract to the appraiser. How do I have the right to send that contract to the lender and the attorney? And how does the lender have the right to send it to the appraiser? The buyer gave us authorization to do that. We got to send it to the people. We have permission to send it to the people that we need to complete this transaction. So we don't have to get special permission to send on their contract. 4, 5, and 6 are all about the buyers. Questions? Provisions 7 and 8 are all about the sellers. So if you're working with sellers, if you're helping them identify what's most important to them, 7 and 8 are all about the sellers. And we're going to start with a seller representation. The first thing they need to represent truthfully, honestly to the buyer is their ownership. Seller represents that they have owned the property for at least 1 year, own the property for less than 1 year, or does not yet own the property. I think sometimes lenders, particularly certain types of loans, care about how long the lender owns the property. I know FHA, for example, they have to own it for 90 days. The flipper has to own it for 90 days. So by us representing how long the sellers own the property, that might be information that the lender cares about. Does not yet own the property. That one's always a little funny, isn't it? The only example I have for that is if the buyer's hiring the builder to build, they might be buying just vacant land. The builder may buy that land, build the house, and then sell it as a package deal to the buyer. So it might be that when we're entering into this contract, the builder's still in process of buying the land. So that may be does not yet own the property. It's in process. That's the only example I've ever seen of that. It's hard to sell something you don't own yet, isn't it?
I've seen sellers use relocation companies, and
Okay, so if like Cardis is going to take it over or something.
yeah, and the listing agent would tell me to check does not yet own the property and stuff like that.
Gotcha. That's a great point, Jory. Thank you. Okay, so seller representations. If the home was built prior to our magic year of 1978, the residential built prior to, we're instructed to include our lead-based paint hazard addendum, one that we'll look at again today, or we'll look at today. Owners Association and dues. Seller authorizes and directs any owners association, any management company, the owners association, any insurance company, and any attorney has previously represented the seller to release to buyer, buyer's agent's representative, closing attorney, or lender true and accurate copies of the following items affecting the property, including any amendments. So with the HOA, any of the documents that could be found or included with the HOA, the seller is going to secure so they can share with the buyer. I think it's important that you and I realize that this exact same list shows up in our listing agreement. This gives us the ability to have the conversation with the seller at the time we're listing the property. Go ahead and gather these documents for me. Isn't a good buyer's agent going to ask for them? So have the seller working on, and guys, it's been my experience that most HOAs will only talk to the current owner. So the seller usually, there's a few exceptions, of course, but most HOAs will only talk to the current owner. So the seller is going to have to be the one to help us to get these documents. Then we're going to spell out who the HOA is. Specific name, whose regular assessments are X amount per month, per year, whatever. Name, address, contact information, website. And then we go through that little exercise again in the event that there's 2 HOAs. Some places may have a mandatory and an optional, for example. It's mandatory to join the HOA, it's optional to join the pool, right? So they may have a couple, just putting it out there for the buyers to representing to the buyers.
Julie, with the HOA, say they're about to go up on fees and they put that notice out that January of 23, the fee will go up. Now the seller is saying that the HOA fee is $250 a month. but it's gonna go up to 550 in January,
Mm-hmm.
and they don't disclose that. How do we get that information if you're saying
We're
that?
not gonna be able to, are we? You know, maybe the HOA will talk to the buyer, the buyer's agents, but that's pretty much on the seller to disclose if they know. And there is a place on here for the sellers to disclose information about, you know, for special assessments, that kind of thing. But to your point, Vivian, if the seller doesn't tell us, how do we know? I mean, I could call the HOA, but it's been my experience, they're gonna say, yeah, if you're not the owner, I'm not gonna talk to you. So we've just, I mean, it doesn't hurt to pick up the phone and call.
Like,
But most
call
HOAs I
them
have
before
will
I-
not talk to me. Jory, you got better experience than
Oh,
I do?
yeah, they tell me how much.
Okay,
But
so,
sometimes like my seller doesn't know, he's a flipper, so I have to call and find out.
but you're calling as a seller's agent, right? You're not
Yeah, I
calling
tell
as a
them that I'm
buyer's agent.
representing. Yeah, if
So,
they wouldn't tell me unless I'm telling them like, hey, I'm representing the seller. Can you please tell me this, and that?
yep.
And they tell me right away.
So Vivian, there you go. We could start with calling the HOA. Maybe they'll talk to you, maybe they won't. What are the dues? Are you planning on those going up? Fuel tanks, this is a new section. Fuel tanks used to be, they had a place with fuel tanks like on page 2, and then again on page 5, and then again on page 12. Fuel tanks were all over the place in the contract, but with this latest revision this past July, they've given us our own little section here on fuel tanks. So it kind of makes it easier keeping it in one place. To the best of the seller's knowledge, there is or is not a fuel tank on the property. If yes, complete the following. So we have the information on tank 1, it's currently in use or not in use. Is it owned or leased? Where is it located? Type of fuel. And then we'll do that again with tank 2. Tanks included in the sale. Buyer and seller agree that any tank described above that is owned by the seller shall be included in the sale as part of the purchase price, free of liens, unless excluded above in our fixtures paragraph. Fuel, this is what's had people in court, buyers and sellers in court. Fuel. Seller may use fuel in the tanks described above through settlement, but may not otherwise remove the fuel or resell it. Any fuel remaining in the tank as a settlement shall be included in the sale as part of the purchase price, free of liens. Seller's use of fuel in any fuel tank is subject to seller's obligation below to provide working existing utilities through the earlier of closing or possession by buyer. Battles over fuel and levels of fuel. What happens is the seller, maybe they didn't know they had to sell. They have the guy come up and fill the tank up, $500 to fill the tank, and then tomorrow they find out they're getting relocated and they have to move. And they say, that's not fair. I just filled my fuel tank. Why don't I get my money back? All right, then just tack on $500 to the purchase price so you can recover your funds that way. I love that the new contract, the revised contract addresses this specifically. Because again, you guys, this is killed deals before. The level of fuel at the closing table has killed deals before. So they've addressed this. Buyers shall be entitled or blue note to conduct inspections to confirm the existence, type, and ownership of any fuel tank located on the property. Buyers advised to consult with the owner of any leased fuel tank regarding the terms under which buyer may lease the tank and obtain fuel. Second note there says state law provides it's unlawful for any person other than the supplier or the owner of the fuel supply tank to disconnect, interrupt, or fill a supply tank with liquefied petroleum gas without the consent of the supplier. So buyer and seller just can't agree to, fill it up from the gas in my car or something. We can't touch it. We can't go in there and mess with it. I think that's kind of sad that we have to put that note in there, but here we are. Make sure everybody's good with that. So seller representations, things that the seller is representing to the buyer to the best of their knowledge. And then 8 is seller obligations. The seller's biggest obligation is to provide evidence of title. They are the ones that are passing on that clear marketable title to the buyer. So the seller agrees to use the best efforts to provide to the closing attorney as soon as reasonably possible after the effective date, copies of all title information in possession of or available to the seller, including but not limited to, there's our title insurance policies, attorney's opinions, surveys, covenants, deeds, notes, deeds of trust, leases, easements, etc. So if the buyer's closing attorney needs anything from the seller to hand over that clear marketable title, the seller's agreeing to work with the closing attorney to provide them the documents they need, whatever they need to do to make that happen. Seller shall provide to the closing attorney all information needed to obtain a written payoff statement from any lender regarding any security interest in the property as soon as possible after the effective date. Seller designates a closing attorney as seller's agent with express authority to request and obtain on seller's behalf payoff statements or short payment statements from any such lender. Usually the attorney, the closing attorney, is the one that will get with the seller's lien holders and get a payoff statement to the day of settlement. So again, this is what the seller's given them permission to call their mortgage company, their lender company, and say, I need to pay off through today, because we got to calculate interest through today, all that good stuff. If seller's not a foreign person as defined by the Foreign Investment and Real Property Tax Act, seller shall also provide to the closing attorney a non-foreign status affidavit. In the event seller shall not provide this affidavit, seller acknowledges that they may be withholdings as provided by the Internal Revenue Code. Authorization to disclose. Seller authorizes any attorney presently or previously representing the seller to release and disclose any title insurance policy in such attorney's file to buyer and both buyers and sellers agents. The property title insurance agent to release and disclose all materials. The closing attorney to release and disclose any seller's closing disclosures. So again, we saw something very similar to that in the buyer's paragraph. If this information is needed to complete this transaction, then we have the right to, the permission, if you will, to pass that along to whomever may need it. Any questions so far? Seller obligations? All right, let's go ahead and take our break. So we'll come back in 10 and keep looking at our contract. Let's take 10. All right. Welcome back. So we are we're getting there. This thing's 16 pages, so I know it's it's a lot, but hopefully you're learning well about our contract as we go through. We've talked about the importance of being familiar with our forms, because as we've discussed, the parties of the contract are not reading this. So we're familiar with it so that we can make sure that they understand, we're explaining it to them and they understand the various points of it. Still under the seller obligations, seller has an obligation about the access to property. Seller shall provide reasonable access to the property through the earlier of closing or possession by the buyer, including but not limited to allowing buyer and buyer's agents or representatives an opportunity to conduct due diligence, verify the satisfactory completion of negotiated repairs or improvements, and conduct the final walkthrough inspection of the property. Seller's obligation includes providing existing utilities operating at seller's costs, including any connections and de-winterizing. So seller has to provide reasonable access to the property through the earlier of closing or possession by the buyer. So remember we said the other day, even though we may be out of due diligence, the buyer still has the right to invest and inspect. So even though we're out of due diligence, if they want to go back, for example, and do the final walkthrough, the seller needs to allow them access. If they want to make sure satisfactory completion of negotiated repairs. That was something we just talked about a little bit ago this morning. So the buyer has the right to come back on the property after due diligence. It doesn't just end when our due diligence does. And the seller's got to keep those existing reasonable access. The seller keeps all utilities in their names, fuel tanks, any of that stuff is going to stay in their name until closing. I've had a few sellers in my career. Man, as soon as we go on, especially vacant homes, if they're not living there anymore, as soon as we go under contract, they want to cancel homeowners insurance. They want to call and cut off the power. It's still their house and they are still the ones responsible for it. So the seller needs to, maybe this is a conversation we have with our sellers, maintain insurance until it closes. Keep the utilities in your name until it closes. Make sure we have those conversations. Our blue note tells us to see the warning in paragraph above for limitation on buyer's right to terminate this contract as a result of buyer's continued investigation of the property following the expiration of due diligence. Comments on that? Seller has the obligation to remove their property. They shall remove by the date possession is made available to the buyer all personal property, which is not part of the purchase, and all garbage and debris from the property. So why is the seller responsible for cleaning the trash out of the corner of the living room? Well, because the contract says. Remember, guys, though, if the buyer signs, that trash in the corner of the living room becomes theirs. So just make sure, I cannot stress the importance of doing that final walkthrough, making sure they know what they're getting, making sure they know what they're signing. Lindsay, your cup matches my shirt. I just noticed that. Oh. Affidavit and indemnification agreement. Again, we saw something very similar with the buyers. Seller shall furnish at settlement an affidavit and indemnification agreement and form satisfactory to buyer and buyer's title insurer, executed by seller, and any person or entity has performed or furnished labor, services, materials, or rental equipment to the property within 120 days prior to the date of settlement, and who may be entitled to claim a lien in the property as described in this general statute, verifying that each such person or entity has been paid in full and agreeing to indemnify the buyer, buyer's lender, and title insurer against from all cause or claim arising therefrom. You guys remember the mechanic's lien? The mechanic is the person that has the right to file a lien on the property if they provide labor or services, or supplies to the property and they're not paid. They have 120 days to file the lien. So what we're asking the seller to do is to sign this affidavit saying this can't happen. Anybody that did work within the last 120 days has been paid. They can't come after the fact. So they sign this affidavit. Designation of lien agent. Seller shall have a designated lien agent. Seller shall deliver to buyer as soon as possible a copy of the appointed lien agent. All deeds of trust, deferred ad valorem taxes, liens, and other charges against the property not assumed by the buyer must be paid as satisfied by seller prior to or at settlement, such that cancellation may be promptly obtained following closing. Seller shall remain obligated to obtain any such cancellations following closing. So if we've gone to settlement, we don't have everything, the seller's still on the hook. Good title, legal access. Seller shall execute and deliver, there's our general warranty deed for the property in recordable form no later than settlement, which shall convey fee simple, marketable, and assurable title without exceptions, for mechanical liens and free from any other liens, encumbrances, or defects, including those which would be revealed by a current and accurate survey of the property, except ad valorem taxes for the current year. We're told to prorate through the date of settlement, utility easements and unviolated covenants, conditions, or restrictions that do not materially affect the value of the property, and any other such liens, encumbrances, or defects as may be assumed or specifically approved by the buyer in writing. The property must have legal access to a public right of way. So again, that's the big thing the seller owes the buyer, isn't it? Is that clean, marketable title, making sure that what they're passing is free of liens, except for which the seller is going to clear up as part of their proceeds. First blue note, buyer's failure to conduct a survey or examine title of the property prior to the expiration of due diligence does not relieve the seller their obligation to deliver good title under this paragraph. So even if the buyer waives the survey, the seller's still on the hook to provide that good title. If they know of any encroachments or whatever, they still need to clear that up. And then our second blue note is about short sales. If it's a short sale, we're instructed to use the short sale addendum. That's another one that we'll look at later today. So we'll see our short sale addendum. Deed, taxes, and fees. Seller shall pay for the preparation of the deed. Seller pays to have the deed prepared, what we learned last week. And all other documents necessary to perform seller's obligation under this contract. They're responsible for paying any excise taxes and any deferred, discounted, or rollback taxes and local conveyance fees required by law. This deed is to be made too. And then buyer's agents, we need to actually put our buyer's names in here. Remember, full legal names. Mr. and Mrs. Ryan Campbell is not how it's going to show up on the deed. So we want Ryan L. Campbell, Julie A. Campbell, anybody that needs to be on the deed. Again, if you want to identify the relationship, this may help the attorney. So if it's not a married couple, for example, you may want to specify that they're brother and sister buying this house, because now the attorney needs to have a conversation with them about how they want to own it. Do they want to go joint tenancy or tenancy in common? I can't give legal advice, and advising somebody on how to take title is giving legal advice. So if you're not working with married people, we just want to make sure we somehow, if not here, somehow point that out to the attorney. Agreement to pay buyer expenses. Seller shall pay at settlement X amount toward any of buyer's expenses associated with the purchase of the property at the discretion of the buyer or lender, if any, including FHA, VA lender, and inspection costs that buyer is not permitted to pay. Right now, what we're seeing is a big zero. That number is going to change though, isn't it? And we're going to have sellers paying buyer's expenses. Again, settlement, closing costs, expenses. Keep in mind, if they're going FHA or particularly VA, there are certain things that the VA will not let the buyer pay for. So for example, isn't this funny? They require the pest inspection, but they don't let the buyer pay for it. So the seller, if the seller is going to be on the hook for paying some of these fees, costs that buyer is not permitted to pay, then the seller have the right to know that you're going to have to pay this pest inspection, only like 85 bucks, 75 bucks, somewhere in there, but still, don't they have the right to know that? Blue Note says parties should review the FHA VA addendum prior to entering into this amount in this paragraph. Certain FHA VA lender and inspection costs cannot be paid by the buyer at settlement, and the amount of these should be included in the bank blank above. So if all you're going to do is ask, let's just pretend that it's a VA buyer and we know that they can't pay the pest inspection. If all you're going to do is ask the seller to pay the pest inspection, then you just put that amount in there. Everybody with me? Whatever the cost of that pest inspection is. Let's say it comes back, we're in a different market and we've asked the seller to pay, I don't know, just $1,000 of closing costs. If the seller's paying the pest inspection, then that $70 is going to come out of the $1,000 closing costs. So if you want $1,000 in closing costs plus the pest inspection, then we need to make sure that that number's, everybody good with that? If you want $1,000 plus, then we need to make sure that that number's included. Of course, you can just call the pest inspector and get the cost, you know, before you fill this in. Again, this is all spelled out in that FHA VA addendum that we'll look at later today. Questions on that? Owners Association fee, back to our HOA. Seller shall pay any charges. Nope, we're not there yet. I'm sorry. Seller shall pay any charges by an owners association or management company vendor as an agent of the association under this paragraph. So some HOAs, most of them, I think, charge like a transfer fee, if you will. They gotta, you know, delete this person and add this person. So there's administrative work behind the scenes. So that just covers the seller, any HOA dues or any HOA fees, the seller is going to be responsible for. Here's our special assessments for the third time in this contract. Seller shall pay in full at settlement all special assessments that are approved prior to settlement, whether payable in a lump sum or future installments, provided that the amount can be reasonably determined or estimated. The payment of such estimated amount shall be the final payment between the parties. So special assessment can impose either by the government and or the HOA. Either one can put a special assessment on the property. The seller is responsible for paying any that have been approved prior to settlement, whether payable in a lump sum or future installments. So maybe they say the whole amount is due by the end of the year, or maybe they say you can pay me X amount a quarter for the next year. You know what I'm saying? They might break it down. Either way, the seller's on the hook for the whole amount once it's been approved. The buyer pays the special assessments that are approved after settlement. What questions do I have on that? Late listing penalties, all property tax late listing penalties, if any, shall be paid by the seller. So in other words, if they hadn't paid 2021 taxes yet, the seller's on the hook for paying those. Here's our negotiated repairs and improvements again. I'm told that they shall be made in a good and workmanlike manner, and the buyer shall have the right to verify same to settlement. Boy, this good and workmanlike manner, that really is subjective, isn't it? You get some homeowners with a hammer and access to YouTube, and they think I can fix it. Some people, I say, are more handy than others. As a buyer's agent, which you may want to consider doing when you're asking for these repairs, that due diligence repair and request agreement, you may want to say to be completed by a certified electrician or a licensed plumber or a general contractor. You may want to specify if you want to make sure that the work is done by a professional and not by a homeowner, that some are better at handyman stuff than others. Let me just leave it at that. You guys got to remember, through the seller's point of mind, at this point, a lot of the times they're done. They're over it. They're ready to move on. So they may not put as much effort into fixing something, knowing that the house isn't going to be theirs next week. So as buyer's agent, the best thing we can do to protect our buyer is request that the licensed or certified person does the work. And as we've been saying, buyer does have the right to verify. That was a terrible line. Buyer has the right to verify prior to settlement. So although the contract doesn't say 2 days prior to settlement, 5 days, we do have the right to verify prior to settlement that these repairs are done in this good and workmanlike manner.
And that they have a warranty for a period of time.
And if they have a warranty, that's right.
Yeah,
That's
Julie,
right.
I'm surprised that it doesn't say, with a Class A contractor or, and I guess, but, all of
Say
our.
that again, Lindsay, I'm sorry. What?
Yeah, I'm surprised that, with negotiated repairs, improvements, it doesn't state with a Class A contractor or a licensed and insured
I gotcha.
contractor.
I
I mean,
know.
that is kind of shocking to me.
I agree. Because
Yeah.
this good and workmanlike manner, this is subjective, isn't it?
Yes.
I mean, I may think that I fixed it and you may come behind me and say, it looks like an amateur did it. It looks like somebody that didn't know what they were doing, but I think it's good, so again, I agree. They don't leave us much room for interpretation, or they leave us too much room for interpretation, I guess I should say. And this is why, again, as buyer's agents, we can take that extra step and put that verbiage in there. If it's something like, it depends on the repair, right? If it's something that I'm not too worried about, then yeah, whatever. But if it's something electrical, plumbing, something like that, I'm absolutely gonna put that verbiage in there. I'm also going to ask for paid in full invoices upon complete, because I want to see that not only did, the electrical company do it,
Mhm.
but they were also paid. So we don't have to worry about having a mechanics lien filed on the property after settlement.
Now, would you
I
put something
agree.
like that in an addendum, your request to see the,
In the due diligence repair and
Okay.
agreement, when I'm asking for the repairs, I'm not only going to specifically say what I want done, but I'm going to say who I want to do it. And I want to see, yep, I'm going to put that all in there.
okay, gotcha, cool.
Yep.
Thanks.
Yep. Thank you.
Mhm.
No, I agree. Both Lindsay and Patricia, to your point. That's it. Good and workmanlike manner prior to settlement. They're not very specific here, is it? So this could be, like Patricia said, if you want time to inspect prior to settlement, then maybe you, in your due diligence repair request, say to be complete, 2 days prior to settlement. So if your buyer wants to send their guy back out there to inspection, now that it's complete, we have that little bit of window to not delay settlement. Other questions or comments? Home warranty, we got some choices here. Select one of the following. Either no home warranties be provided by the seller. The buyer may obtain a 1-year home warranty at a cost not to exceed X amount, which includes sales tax, and seller agrees to pay for it at settlement. Or sellers obtain and already will provide a 1-year home warranty. Here's the name of the company and the cost that the seller's paying for it. Just keep in mind, you guys, it says which includes sales tax. So when you see the price on a home warranty brochure, they may have several different options. This is the basic, this is the special service, whatever. When you see a price on the brochure, it just gives you the price of the home warranty. It doesn't include sales taxes. So make sure that if you're filling this amount in, that you have enough in here to cover the cost of the warranty and the sales tax. I know sometimes sellers get nervous because they think, if you put 650 in here, and then we find out that the home inspection is 600 plus, I'm just kind of making numbers up, $30 in sales tax. Now the whole thing is only $630, right? The seller, a cost not to exceed. If I put in 650 and the home inspection with taxes is 630, the seller only has to pay 630. They're only paying for the amount of the warranty, not to go over that's $650. So that might help alleviate. They're not going to, does that make sense? They don't have to give you $650. They're just agreeing to pay a cost not to exceed this amount. And that does include sales taxes. So what I tell you as a buyer's agent, make sure you get enough in there to cover the warranty and the taxes. Does that make sense? Blue note says home warranties typically have limitations on and conditions of coverage. Refer specific questions to the home warranty company. And then the last little piece of this is in the event of seller's breach. And again, we got a whole new provision down in paragraph 23 for that breach. We are getting there. Questions on sellers' obligations or sellers' representations. Again, I like that the contract kind of gives buyers its own little section, sellers its own little section. I used to work with a lady, I don't know if she still does it or not, but I used to work with her, and each year this contract, when they revised the contract, she would print out a copy, and then she would color code the contract. So for example, if it was about the seller, she would highlight it yellow. If it was about the buyer, she highlighted it blue. If it was about money, she highlighted it green. So she would kind of go through and color code the contract and then make copies of that. So when she gave a sample to her clients and she was working with the seller, she could say, everything yellow and green is what you need to pay particular attention to. Again, are the sellers sitting down looking at everything yellow? I don't know, but at least she's doing her part to help them get the information, and even taking it a step further, isn't she? And directing them to these specific pieces that are about the seller. So I always like that she did that. Try to help her clients out. Nine is charges about an owner's association. Again, this is something new we just saw added this year. This is the fourth place we've seen about owners association. So it is still kind of all over the place, but we're bringing it home a little bit. Responsibility for payment of charges by an owners association or management company shall be allocated between buyer and seller as follows. So fees that the seller shall pay, any fees in completing the RPODs is the seller's responsibility. Anything for confirming the seller's account. Assessments, payment of proration, that's the seller's responsibility. Any fees charged for transferring or updating ownership records. Any fees other than those specifically required to be paid by the buyer. When it comes to owners association, the buyer shall pay charges for providing information required by the buyer's lender, charges for working capital contribution, membership fees, etc., move-in fees, that kind of thing, and charges for determining restrictive covenant compliance. So it breaks down the various fees in regards to owners associations. Ten is about prorations and adjustments. Unless otherwise agreed, the following items shall be prorated, with the seller responsible for the prorated amounts of any taxes and dues through the date of settlement. Seller entitled to the amount of prorated rents through the date of settlement and either adjusted between the parties or paid at settlement. There's our property taxes, personal property taxes, rent, and HOA dues. So like we talked about last week in chapter 14, one of the things that we typically prorate between buyer and seller, this year's taxes, rent, and HOA dues. Eleven is condition of property, risk of loss. Condition of property at settlement. If the property is not substantially the same or better condition at closing as on the date of this offer, reasonable wear and tear expected, buyer may terminate this contract by written notice delivered to seller, and the due diligence fee and earnest money shall be refunded to the buyer. Let's look at that again. If the property is not in substantially the same or better condition at closing as on the date of this offer, the buyer may have the right to terminate, and if they do, they will get their due diligence and their earnest money back. This again leaves a lot of what ifs, doesn't it? I mean, I think, what if the house burns down while we're under contract? The buyer may terminate. If they do, they'll get their due diligence and earnest money. What if the seller doesn't repair this hole in the wall that was hidden by a poster? Well, is that considered condition of property, risk of loss? Again, you guys, I think they leave this out open for interpretation. And remember, bottom line, if the parties can't agree to agree, then a judge will decide for them. So if the seller considers this hole normal wear and tear, reasonable wear and tear, and the buyer says, no, it's not, I want it fixed, and the seller's not willing to do it, we just may have to get somebody to decide for them.
But that is so good that it's even in there.
Yes,
And you
yes,
bring this up at the listing presentation so that
yes,
you ought to consider, and have the right mindset for what needs to be done, because
exactly.
tables turned, they would want to give a property that was in good condition.
Exactly,
And
exactly.
that's how I try to
Yep.
a little bit.
And to your point, Patricia, I mean, guys, remember, we can't go around touching personal property. Buyers can't go in the house and touch. So the only way the buyer knows that there's a hole behind this poster is if he moves it. Well, we can't touch this poster. This is personal property. You guys with me? So to Patricia's point, this might just be conversations we have to have at the listing. You have a whole bunch of pictures up in your house. You're not hiding any big holes or anything, are you? Ha ha ha. But we may just have to have these conversations so we know what the property looks like. So if the buyer terminates, if they choose, they got choices here. The house burns down while we're under contract. It's not over yet. If the buyer chooses to terminate, they'll get their earnest money and due diligence back. If the property is not in such condition and the buyer does not elect to terminate this contract, buyers shall be entitled to receive, in addition to the property, the proceeds of the insurance claim filed by the seller on account of any damage or destruction of property. So we go under contract, the house burns down. It's not over. The buyer has choices. They can either terminate, get their earnest money and due diligence back, or they can go ahead and buy the property, get the seller's insurance to rebuild. If I were the buyer's agent and the house burned down while we're under contract and the buyer looked at me and said, what should I do? I'm going to tell them to talk to their attorney, and I'm going to tell them to talk to the seller's insurance company, because I think those are the two people that can get them the answers to the questions that they need. I present the facts for them to make an informed decision. So I'm telling them, you guys have choices. Before you continue on with purchasing, why don't you do further investigation? Talk to an attorney, talk to the seller's insurance company, and get more information before you decide which to do, to terminate or not. Thoughts on that?
It could turn out to be a great deal for the buyer.
It could. If they're thinking about continuing on and getting the seller's insurance proceeds, it's coming down to location, isn't it? I mean, that's pretty much, they really, really want to live there, or the land is something that's attracting them, drawing them. But you're right, they could rebuild better than before, right? It could be better than so it could work out for them.
And everything would be new.
And everything would be brand new.
Current
So
building code.
again, Julie, what should I do? I cannot make that decision. What I can do is advise them to talk to other people so they can make the best decision for them. Unfortunately, too, you guys, please note, if the buyer terminates because the house burns down, all they're getting is their due diligence and their earnest money back. If they have spent any money on the home inspection, appraisal, anything like that, they're not going to recover those costs. Then we have the risk of loss. Risk of loss or damage by fire or other casualty prior to closing shall be upon the seller. Sellers advised to not cancel existing insurance on the property until after confirming recordation of the deed. So the seller, it's still their home. And if the house burns down, that risk is on the seller. I can't tell you how many times I've gone under contract and my seller has said, woohoo, we're going to cancel insurance and save some money. No, it's still your home. You got to keep it insured. So make sure you have these conversations. And, let's talk this through for a second. If the seller's insurance coverage is ending the day of settlement closing, the buyer's new policy is beginning that day. So technically the home's going to be double insured on the day of settlement. If the house burns down on the day of settlement, who's responsible for it? I think it's coming down to a date and time or time stamp now, isn't it? I would think maybe both of them, Patricia, I'm not sure. But if the house burns down at 9 a.m. and the deed gets recorded at 2, when the house burned down, it was still the seller's, right? If the deed gets recorded at 9 and the house burns down at 2 p.m., now it's the buyer. So who's going to be responsible? If I were the insurance company, I would first want to know what time did it burn down and what time was that deed recorded before I agreed to pay anything out. But you're right, Patricia, bottom line, the two and their insurance companies may have to, duke it out. Hopefully it doesn't burn down on the day of settlement, but crazier things have happened. Comments on that? Guys, also remember, if your seller is going to vacate the property, they got to move out at some point prior to settlement, right? But if it's going to be weeks or months prior to settlement, we need to encourage the seller to contact their insurance company and claim the property is vacant. Their cost for that time may go up, but if something happens to the property and they don't know that it's vacant, insurance company may not cover it. Insurance may say that home wouldn't have been vandalized if people had been living there. So failure to report it might mean that insurance won't cover it. Delay in settlement. Who remembers how many day delay we got built in? How many day delay do I have built in? Yep. Vivian's nodding in agreement. So our contract gives us a 7-day delay. That's right. Your book probably still says 14 days because that's what it was until like last year. This is a pretty recent change. So where is it in your book?
It's
It's
page
somewhere.
393.
Got it, 393. Thank you. So 3. Yep. There's our sample contract. That thing was 2020, so that thing is pretty old. But yeah, anytime you guys see it in your book that has 14-day delay, as of July 2021, that change is just over a year old. It's now 7 days. So delay in settlement, this paragraph shall apply if one party is ready, willing, and able to complete settlement. They're known as the non-delaying party, but it's not possible for the other party to complete settlement by the settlement date. They're known as the delaying party. In such event, the delaying party shall be entitled to delay in settlement and shall give as much notice as possible to the non-delaying party and the closing attorney. If the delaying party fails to complete settlement within 7 days, then the delaying party shall be in breach and the non-delaying party may terminate this contract and shall be entitled to enforce any remedies available to such party under this contract. Probably one of the more common reasons for delay, is we haven't gotten loan approval yet. We're close. Everybody's doing what they did. We just haven't gotten it finalized yet. Remember, we got 3 days that the buyer has to see the closing disclosure. So if they don't see that CD within 3 days, we have to delay settlement, have to do with the loan. So in the event, for example, if the reason that we're delaying is because for whatever reason we don't have loan approval yet, that makes the buyer the delaying party and the seller the non-delaying party. Everybody with me? The buyer's the one that's causing the delay. The seller is the non-delaying party. What this means for the buyers, they now know they got 7 days to try to work really hard with their lender to get it right, to get it approved. The seller, as the non-delaying party, has no other choice but to sit there and be patient and hope that it closes within 7 days. The seller cannot terminate during this delay without suffering the consequences of breach.
Do the sellers ever do a per diem anymore?
Do what?
A per diem?
If they do, then we're gonna have to have somebody drafted up, because I don't have verbiage for that in our contract. So what you're saying is if the seller says you owe me X amount per day, you know, is that,
Yes, ma'am. Or sometimes even in the case of a new home, a new build, sometimes, you know, the builders want X amount of dollars per day if they don't close by that day.
right?
Because
So
they're,
that would just have to be a separate agreement between the two. We don't have anything. Yep, thank you. So the seller was waiting patiently 7 days. On day 8, now they can terminate. Okay, but those 7 days delay, they can't. They just, the non-delaying party, just again, they're just sitting there patiently, fingers crossed, hoping that we can get this to work out. Remember, we can extend our settlement date. We looked at our agreement to amend the contract last week. If we extend the settlement date, we're also having a 7-day delay. Or if we check that little box in the agreement to amend, we could have a 4-day delay. But you're always going to have a delay in settlement. The reason they told that class I took a few months ago, and the lady from the forms committee taught it, she told us, this blows my mind, the reason that they changed it from 14 days to 7 days is because too many buyers agents were taking advantage of that. They were trying to have an earlier close date in the contract to get their offer to be more, to look better to the seller. And then as soon as they go under contract, they were saying, we're going to enact our 14 days. And that wasn't what it was for. They abused it. They abused it. The delay in settlement shall apply if one party is ready, willing, and able, but it's not possible for the other party. So in other words, we shouldn't be banking on that 7 days. We're all working for the date. Delays just happen. Does that make sense? That's just crazy to me that these are the kind of things that we have to do to try to prevent, but here we are. People abuse it and we lose it, right? So they abused it and we lost 7-day delay. Now we're just down to that. Comments on that? Possession of the property, including all means of access, keys, codes, security codes, garage door openers, shall be delivered when? Upon closing, not settlement. Settlements when the buyer's there. Should the buyer walk out of the attorney's office with a key to the front door? No, it's not until that brand new deed is recorded. The last act of closing is the recordation of the deed, and the contract tells us that's when the buyer should get possession. Unless otherwise provided below. So there's a buyer possession before closing, a seller possession after closing, or possession is subject to right of the tenant. So we're going to look at both of these, buyer possession before and seller possession after, and all of our fun forms that we're looking at later today. We're also, a note just reminding us these situations may call for other forms. So again, you guys, by being familiar with our contract, it tells us when to use a form. So I like that. This is one reason why we are familiar with our contracts. Addenda, check all standard addenda that may be part of this contract, if any, and attach. Itemize all other addenda of this contract, if any, and attach. So now it gives us a list. These are the addenda that the contract has pointed out throughout, most of them. But now it kind of gives us, I use this as like a last minute checklist. Let me make sure I got my FHA VA. Let me make sure I got my lead-based paint. Let me make sure I got the addenda that need to be included. But we're just going through and identifying what addenda are going to be included in this offer. Here's an other. So if you have an attorney drafted or a party drafted addenda, we have the place to put that in. Our blue note says under North Carolina law, real estate brokers are not permitted to draft addenda to this contract. That's the second time we are told I can't draft. So make sure, you know, we get it, right? But our buyers and sellers don't know. And I think it's really common for them to look at us and say, can't you just draw me something up real quick? You know, you're my agent. I hired you. You have to do what I tell you, right? We do to the extent of the law. So that's why this is why we keep hounding you guys on we are not attorneys, because you and I know that, but our buyers and sellers don't. So when we are asked, not if we are asked, but when we are asked, we need to know how to respond. It's not their job to know my job. That's my job to know my job. Assignments. We talked about an assignment last week. An assignment is one where all the terms stay the same. The only thing that changes is the name of one of the parties. Remember, the parties of this contract are the buyers and the sellers. So this contract may not be assigned without the written consent of all parties, except in connection with a tax deferred exchange, which we'll look at next. This contract shall be binding on the assignee, their heirs, and successors. So could this contract be assigned? It could if I have written consent of all the parties. Remember, the parties of this contract are buyer and seller. So if somebody else wants to buy, our buyer could assign to a new buyer as long as we have, and now we're getting into some legalities, aren't we? So probably want to get an attorney, but it could if the parties agree. A tax deferred exchange, before we look at this paragraph, let's just talk briefly about what a tax deferred exchange is. This is an IRS benefit for investors. And what the tax deferred exchange does, it allows an investor to use the proceeds of the sale of one investment property to purchase another investment property. And as long as they are selling an investment property and taking that money to buy an investment property, they can defer paying their capital gains taxes. Nice program for investors. If you're an investor or if you're working with investors, it's advised that they talk to their accountant to make sure that they're taking advantage of that. There's certain rules, like they have to buy within, I think it's 6 months, don't hold me to that. So there's some other various rules and stuff that would apply. In the event buyer or sellers desire to effect a tax deferred exchange in connection with the conveyance of the property, buyer and seller agree to cooperate in effecting such exchange, provided, however, that the exchanging party shall be responsible for all additional costs associated with such exchange, and provided further that a non-exchanging party shall not assume any additional liability with respect to such tax deferred exchange. Buyer and seller shall execute such additional documents, including assignment of this contract in connection within, at no cost to the non-exchanging party, and shall be required to give effect to this provision. So if the buyers or seller is acting as a, in this tax deferred, the person that's doing the tax deferred exchange will be the one responsible for those costs. Parties to the contract shall be binding upon and shall inure to the benefit of the seller and their heirs, successors, and assigns. When do heirs kick in? Heirs don't kick in until the individual passes away, do they?
Yeah.
So remember what we said last week. Once you're under contract, death is not an out. Death is only an out when you're negotiating the offer. This contract shall be a binding upon their heirs or successors. If the heirs can't or won't carry through with the terms, they're in breach. Words of the singular include plural, and masculine includes the feminine, neuter genders is appropriate, just identifying the parties. Survival, if any provision which by its nature and effect is required to be observed, kept, or performed after closing, it shall survive the closing and remain binding. The entire agreement, this contract contains the entire agreement of the parties, and there are no representations, inducements, or other provisions other than those expressed herein. Changes, additions, or deletions here too must be in writing and signed by all parties. Nothing contained shall be any agreement between a realtor or a broker and seller or buyers contained in any listing agreement, buyer agency agreement, or other agency agreement. So remember, the big picture says we do not belong in the offer to purchase and contract. So any agreement that we have between our buyers and sellers does not belong here. That's why we have agency agreements. Make sure your compensation is spelled out there. Conduct a transaction. The parties agree that any action between them relating to the transaction contemplated by this contract may be conducted by electronic means, including the signing of this contract by one or more of them and any notice or communication given in connection with this contract. Any written communication, notice or communication may be transmitted to mailing address, email or fax set forth below in our notice information. Any notice of communication to be given to a party, any fee, deposit, or other payment to be delivered may be given to the party or to such party's agent. Delivery of any notice to a party via means of electronic transmission shall be deemed complete at such time as the sender performs the final act in a form capable of being processed by the receiving party systems to any electronic address provided for such in the notice information below. Buyer and seller agree that the notice information acknowledgement of earnest monies below do not constitute a material part of this contract and that the addition or modification therein shall not constitute a rejection. So what we're telling you is the last 2 pages of these contracts, this contract that we're getting to, isn't going to break or make the deal. We're going to see in just a minute where the parties sign, and that's officially the end of the contract. Failure to complete the notice or failure to complete the acknowledgement of receipts that we'll see is not going to be a deal breaker for this contract. The other thing I want to point out that this says, we talked about this last week, having permission to do electronic means. So not only do we see that in .loop when we go to sign, DocuSign, SkySlope, etc., but it's also discussed in our contract as well, that once you agree to do electronic means, your electronic signature counts as your legally binding signature. There is no getting out because it doesn't look like my signature. Once you agree to do e-signatures, you're in. This contract can be signed in multiple origins or counterparts, all together constitutes one and the same instrument. So I think, again, this is more common for electronics when we're all using paper copies. You might have had the same contract, just 2 different versions, one signed by the buyer, one signed by the seller. As long as they're the same, then we can have multiple originals, multiple counterparts. We're just not seeing that as much anymore now that we have electronic signatures. It's much easier to get everybody on the same page, literally. Computation in days, unless otherwise provided, the term days shall mean consecutive calendar days, including Saturday, Sunday, and holidays. So when you're counting contract days, a day is a day is a day. Remember when we counted closing disclosure days, Sunday and holidays don't count. So there's a difference there. When you're counting contract days, a day is a day is a day. For purpose of calculating days, we're going to begin day 1 on the following day, upon which any act or notice is provided. Any reference to a date or time shall refer to the date and time in the state of North Carolina. In other words, Eastern Standard Time. I remember when that last sentence was added, it was a lawsuit. Dude was out in California. Due diligence was running up. He said, well, it may be 4:30 your time, but it's 12:30 my time. And there was nothing in the contract that specified. So now they put a sentence in there. It's the time and the day that the property is located. The property is in Eastern Standard Time. There's a reason why some of this verbiage is in the contract. 2 people go to court over something like this, and we all get the the verbiage. All right, provision 23 is our last provision before we look at other things. Again, this was recently added. This was July of 2021. The remedies for breach used to be scattered all throughout. But they decided that we need this to stand out a little bit more. So they created its own paragraph and called it remedies. I like that they separated it. I like that they pulled it out so we had it together in one place. I wish they didn't put it at the very end. I fear sometimes that by putting it at the very end, it kind of gets mixed around. I wish they would have put it somewhere closer to the beginning. Nobody calls and asks me. So it's just my opinion, but we now know it's there. We know that there's a remedies provision for buyer and seller. So breach by the buyer. In the event of material breach of this contract by the buyer, the seller shall be entitled to any earnest money deposit, the payment of the earnest money and due diligence fee to the seller without regard to their respective amounts, including zero, shall together serve as the seller's liquidated damages. Remember, liquidated damages or money damages that we talked about in Unit 9. Let's go the whole way back to last Monday. And we talked about some money damages. Liquidated damages are money damages that we agree when we enter into the contract. Don't we negotiate the due diligence fee? Don't we negotiate the earnest money? So because these are amounts that are agreed upon when we enter into the contract, and again, listing agents, you need to make sure that your seller is good with these amounts, due diligence and earnest money, because they're their liquidated damages. And as the contract goes on to say, it tells us they are the seller's sole and exclusive remedy for the buyer's breach. So if your buyer terminates hours before settlement, what does the seller get? One hour before settlement, what do they get?
Earnest and due diligence.
And due diligence,
And
liquidated.
that's it. Everybody with me? 1 hour before, buyers call and say, I ain't coming. Your seller has made other arrangement. They had to sign a lease or go under contract to buy another house, right? They have to have somewhere to live. So this is why, and this is where I think this is important, as we're watching this market change, as we're watching things happening, that shift, we're going to see earnest money and due diligence start to come back down. Right now, sellers are riding high on their $50,000 due diligence and or earnest money. But that's going to come back down. But that doesn't negate the fact that listing agents, we need to make sure our seller understands that by accepting that due diligence and that earnest money, that's it. It's acknowledged by the parties that the amount of liquidated damages is compensatory, not punitive. We're just trying to make them whole again. Such amount being a reasonable estimation of the actual loss of seller would occur as a result of the breach of this contract. The payment to the seller of the liquidated damages shall not constitute a penalty or forfeiture, but actual compensation for seller's anticipated loss, both parties acknowledging the difficulty of determining seller's actual damage for such breach. Again, the consequences for the seller to breach are getting ready to be much harsher than the buyer. Is everybody good with that? The buyer breaches, earnest money and due diligence, and that's it. What if the seller breaches? Well, if the seller breaches, the buyer may elect to terminate this contract as a result of breach. Such shall entitle the seller to return, the buyer to return of both. So the buyer will get the earnest money and the due diligence, together with the reasonable costs actually incurred by the buyer as part of their due diligence. So if the seller breaches, the buyer, and if they're not willing to sit down and write a check, the buyer can go after them. So if the seller breaches, the buyer can go after earnest money, due diligence, plus any costs that they've already paid. Have they had the home inspection done? Have they had the appraisal done? Pest inspection, survey? Did they have to take an afternoon off work to meet the home inspector at the property? These are all things that they can prove, right? You can show with an invoice or a receipt that you paid for these things. You can show due to lost hours of work. The seller is responsible for providing all that to the buyer. And again, if the seller's not willing to sit down and write out a check, then the buyer can sue them. Yes, ma'am.
Even so, say the buyers have given notice to their apartment complex and there is no more vacancies at the moment.
So now they got to find somewhere else to live, don't they?
Where to go?
That could absolutely be a,
They've rented a
you
truck.
know, because we breached this lease as a consequence of your, and now I got to find somewhere else to live. So that's a great point, Patricia. And as your, as a buyer's agent, we may have to get an attorney involved to make sure we're getting what's best, what's right for our buyer, hadn't we?
Julie, does this happen often?
I don't know about often. Has it happened? Yes. Yes. Not to me personally. I had sellers that thought they were going to terminate. Y'all want to know what happened? We go under contract and they're like, I mean, I couldn't sell their house fast enough. This is before this market when, I mean, the house is only on the market for like 2 or 3 weeks. It wasn't long, but couldn't sell it fast enough. They couldn't get it by. I mean, they were ready to go. Guess what, y'all? They woke up one morning, they went to Walgreens and got a test. And guess what? Lo and behold, we're pregnant. We're going to have a baby. We're already under contract. You know what they did? They called me and they said, Julie, we don't want to sell our house after all. We're under contract. I said, ooh, well, first off, congratulations. Let's welcome your little bundle of joy. But you are still in a legally binding contract. I said, before you guys make a further decision, you need to talk to your attorney because you need to know if you terminate this contract, what might happen. I can't tell you what's going to happen, but the attorney needs to have well, they didn't want to make that phone call to the attorney. Do we have to? No, you don't have to do anything. But how do you know the consequences of your breach if you don't talk to an attorney? So in the end, they decided to close and buy something else. They were not happy about it. This is a legally binding contract, you guys. And because we're now pregnant isn't an excuse to get out of a legally binding contract, unfortunately. So Vivian, the closest I ever got was that. And I just had unhappy sellers at the end of the transaction because they didn't want to get involved in the legal. And I can't blame them. I can't blame them. But what that taught me is some sellers need to hear, once you start this process and you get a buyer under contract, you're in it, guys. You can't change your mind. This is it.
That needs to be so stressed in a listing presentation.
They don't get it, do they, Patricia?
No, they don't get it because their emotions are high and they're excited
Uh-huh.
about the property. But say that it happened about the pregnancy in the due diligence time.
The
It's
due diligence is only the buyer's right to terminate. It's not the seller's right. Like you said, once your seller's in, they're in.
Yeah. I've
So
had
then
that.
they tried to get these guys like the repair request came and they said, we're not fixing anything. And I said, that's your right. You don't have to. And the buyer's agent was like threatening us and, you know, da, 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 but they were hoping these buyers would terminate. You know what? They called their bluff. My guys didn't fix a single repair. And the buyer said, yeah, we're still going to buy. So I think to Patricia's point, I think you're absolutely right. With sellers, this is a conversation we need to have back in the day of the listing appointment. You'd like to think nobody's going to try to back out, but you never know when life happens. Like Patricia said, this is a very emotional process. So we just need to make sure they understand that when they're in, they're in. So the buyer's choices, they may terminate this contract and get their money, or they may elect not to terminate, treat it as remaining in full force, and effect and seek the remedy of specific performance. Remember, we talked about specific performance the other day. The buyer could sue the seller, and if they win, the judge could make the seller perform. And what is the seller's performance? To sell the house. So if the seller's in breach, the buyer either terminates and goes after all their money, or they keep the property and go after specific performance and make the seller sell. Attorney's fees if legal proceedings are bought by buyer or seller against the other to collect the earnest money deposit, due diligence fee, or due diligence costs. The parties agree that a party shall be entitled to recover reasonable attorney fees to extent permitted under this North Carolina general statute. The parties acknowledge and agree that the terms of this contract with respect to entitlement to earnest money, due diligence fee, or due diligence costs each constitute an evidence of indebtedness pursuant to this general statute. In other words, this contract gives the verbiage to allow the party that has to sue to recover not only what they're suing for, but they could also go after the other party for their legal fees as well. So if we terminate, you have somebody digging their heels in, they don't want to sign, they're upset, I get it. Nobody likes to terminate, and I get it. But we may need to look at our person and say, not only will you be sued, because this is what the contract says, not only can you be sued, if you are sued, you will lose. And if you lose, not only will you have to pay your attorney's fees, but now you may have to pay the other guy's attorney's fees as well. If they won't sign and they're refusing to do it, the two just may have to hash it out in court. Our blue note here says a party seeking recovery of attorney's fees under this general statute must first give written notice to other party. They have 5 days from the mailing of the notice to pay the outstanding amount without the attorney's fees. Questions or comments on that? Again, this was just added. This stuff has always been here, but now it's in a nice place for us in this remedies paragraph. North Carolina Association of Realtors and the North Carolina Bar Association make no representation as to the legal validity or adequacy of any provision of this form and any specific transaction. Gee, there's their disclaimer, isn't it? They provide us this form, but they put themselves in a sentence to make sure that I can't be held liable. If you do not understand this form or feel that it does not provide for your legal needs, you should consult with an attorney. When? Before you sign it. Once you sign it, it is too late. So if you're a buyer or seller are questioning the legal validity of it, if they're questioning if it meets to their specific needs, we need to get them to an attorney. Don't have them sign it and then we'll deal with it. Once they sign it, it's too late. This offer shall become a binding contract on the effective date. We define that back on page 2. Unless specifically provided otherwise, buyer's failure to timely deliver any fee, deposit, or other payment shall not prevent this offer from becoming a binding contract, provided that any such failure shall give seller certain rights to terminate, as we discussed in this contract and permitted by law. Remember, we got a provision. Question always comes in, what if they don't deliver the due diligence? What if they don't deposit the earnest money in time? Let's go back to page 2. We have that provision that says if they're not delivered on time or if they bounce, the seller provides written notice, and upon receiving written notice, the buyer has 1 banking days to provide those funds. Non-receipt of due diligence, non-receipt of earnest money doesn't affect the validity of this contract. Everybody with me? We just have another remedy to get it if they don't happen, but we're not going to have this isn't a contract breaking thing. It doesn't make or break a valid contract. Buyer signs on the left, seller signs on the right. If you have an entity buyer or an entity seller, you have a place for them to sign as well. Yes, ma'am.
So would it be, if you don't receive the funds, that would create a voidable contract?
No. If we don't receive the funds, the seller provides written notice, and then the buyer has 1 banking day to deliver the funds. And within that 1 banking day, if they don't, the seller may terminate.
So at that point, it becomes a voidable.
Nope. They just have the right to terminate if they choose.
Okay.
The contract is still valid. We just gave the seller a reason out. Okay. Good question. Thank you. Remember, I can't determine if a contract is valid or voidable. That's the judge's job. But what the contract does say is that if you don't do this, my guys have the right to terminate. The seller may terminate. Does that mean they have to terminate? Absolutely not. They may terminate. They have that right. Guys, technically, where are we? We're somewhere on page 14. Technically, this is the end of the legally binding contract. The rest of this that we're going to look at after break is just more informational purposes. But when the judge is looking at the contract, this is what they're going to look at is the first, 13 and a half pages. By them signing here, they are signing everything above is the legally binding contract. So the rest of what we're getting ready to look at is just additions and add-ons, things that help keep the contract process moving. So let's go ahead and take our break. There's my chat. It's 11:33. Let's come back at 44. And we'll finish this thing up. You already be done with this one? 11:44. So let's take 10. All right. We're back. So the rest of this, let's see, we should have a couple others. So buyer and seller have signed. Again, the rest of this is just kind of informative. There's a wire fraud warning to both buyers and sellers. For those of you that are not yet familiar with North Carolina forms, when you look at our listing agreement, there's a wire fraud warning to the sellers. When you look at our buyer's agency agreement, there's a wire fraud warning to the buyers. Now that we're looking at the offer to purchase and contract, we got a wire fraud warning to both. So buyers and sellers, and I'll let you guys read this, but bottom line, what this is saying is we as agents, one of the best things that we can do to protect our buyers and sellers from wire fraud is to look them in the eyeball and tell them, I will never email you wire transfer instructions. So if you receive an email that looks like it's from me with wire transfer instructions, you need to let me know because I've been hacked. I'm telling you, I will never do that. Hackers get into our emails. They send out emails that look like it came from us. They get fraudulent wire fraud, wire transfer information, send it to that off-seas account, never to be seen again. Okay, so we just need to have that conversation. Wire fraud, Lindsay and Patricia are aware of this, has gotten really big, really fast in real estate. And it's an easy way. I've heard recently that billions, that's with a B, billions of dollars have been intercepted from real estate closing transactions from the table. So just make sure we're doing what we can. Just some other pieces of advice for you guys. All our passwords shouldn't be password 1234, especially with accounts that you have your client's confidential information. I know it's a pain in the rear to have different passwords. Yeah, password 1234, that's not a secure password. Everybody, that's what they always try first when they're trying to hack into your account. Try to have some kind of password. Like I said, I know it's annoying. I sit in my living room and look at stuff in my living room to create a password, things that'll help me, help me trigger those. Another thing you may want to consider is putting a two-step verification on your email. So not only do you have your password, but then it sends you a code or a text that you need that as well. So if somebody else tries to enter your email, they need that code or text that your phone's going to send you. Be careful when you connect to a public Wi-Fi somewhere. If you're going to go to Starbucks this afternoon to work, take your laptop and go get you a coffee and sit there and work. Remember, when you're hooking up to Starbucks public Wi-Fi, who do y'all think can access that? The public. So while you're sitting there at Starbucks working on your public Wi-Fi, the hacker may be sitting behind you, getting into your device. So if you're going to do that, access through your mobile hotspot on your phone. Don't go through the public Wi-Fi. Go through the mobile hotspot. Comments on wire fraud. Like I said, it got really big, really fast in real estate. Okay. Page 15 is the notice information. This is how the parties want to communicate with each other. Now, every agent handles this first part differently. I'm going to advise you to talk to your firm, how your firm wants you to handle this. But the first part of the notice information, first off, our blue note tells us to insert at least one address or electronic delivery address each party and agent approves for the receipt of any notice contemplated by this contract. Insert an NA for any which are not approved. So then we have a place for the buyer's notice, buyer's contact, and the seller's contact. Some firms will say fill it in, other firms will say don't. So again, how you want to proceed, some agents, I get it. Some firms say, well, if I give you my seller's contact information, then you know how to get a hold of my seller. Some firms want to keep that information confidential. So remember, the only thing that this page should be used for is contacting each other to form the contract. How do we want to be notified and communicated with during the contract? This should not give us another name to add to our emailing list. You guys with me? Because it's somebody else's client, it's not mine. So don't use this as a means, which is why some firms say don't do it. Just put NA in here. So I'll let you guys as firm advise. What we do want to make sure that we're filling out is our piece of it. Don't you want the other side to contact you directly? If I'm the listing agent, I don't want them calling my seller. I want them calling me. That's why they have me. So confirmation of agency and notice address. Again, buyers are on the left, sellers are on the right. So we have the selling firm. We need to identify as a selling firm acting as the buyer's agent, seller subagent, or dual agency. The firm license number and mailing address. And then we're going to identify the individual selling agent. Select if they're acting as a designated dual agent. License number is required. And then however you want to be contacted. And then we go through that same little exercise on the right with the listing side. Listing firm acting as seller's agent or dual agent. And then the individual listing agent. So Real Estate Commission rule requires us to identify our role in writing. So the contract helps us with that. We can actually check a box and that identifies our role. Comments or questions on the notice page? I don't have a fax number, but other than that, I give them everything. I give my office mailing address, not my home mailing address, y'all. My office mailing address, phone number, email. I want you to know how to get in touch with me. And then the last page, we made it. The last page is the acknowledgement of receipts of monies. So now we're under contract and money has to start changing hands. We got to get the due diligence fee to where it needs to go. And we get the earnest money where it needs to go. So you're the buyer's agent. You go under contract. Yay. Get that contract to the lender so they can start their thing. Then you call the buyer and say, as we discussed, now that you're under contract, you owe me 2 checks. When and where do you want to meet? So you meet up with the buyer, you get the checks. They're going to hand you 2 checks, one for earnest money and one for due diligence. Buyer's agent is then going to deliver those checks where they need to go. So with the due diligence, the buyer's agent will deliver to the listing agent, upon which at that time, the listing agent will sign, acknowledge, and receipt of the due diligence fee. How much was it? Date, who received it? Can we all go ahead and agree that on its way and in your hand are 2 different things? Can we agree that on its way and in your, can things happen from me delivering it from here? Absolutely. Guys, there have been cases reported to the commission where the due diligence has gone missing. And the Real Estate Commission has requested this form. And they get this form and they see, lo and behold, that the listing agent has signed it. And they go to the listing agent and said, you signed, acknowledge, and receipt. And you know what they've heard in the past? The listing agent saying, well, I never got it. They said they were going to drop it off after lunch. So I went ahead and signed it, but I never actually got it. Who's on the hook for it? The listing agent, because didn't they sign, acknowledge, and receipt? So y'all don't sign for it. Can we all agree to not do this? Don't you sign for it until it's in your hand. Don't you sign for it until you have it. Okay. Once the listing agent gets the due diligence, then they're going to get it to the seller, in which case the seller is going to sign receipt of due diligence fee. So pretty much whenever it changes hands from buying side to listing side to the seller, whenever it changes hands, we have to sign, acknowledge, and receipt. The escrow agent acknowledges receipt of the initial earnest money. Again, once you drop it off, if it's your firm or if it's the attorney, whomever the escrow agent is. And then if there's additional earnest money, and you will note with additional earnest money, we also have a timestamp because additional earnest money is a time is of the essence. So whomever's the escrow agent is receiving it, they need to acknowledge a receipt at this time to make sure we're within that time is of the essence. It's a drop dead date and time. And that, ladies, is your now, as of July 1st, 16-page offer to purchase and contract. Last year it was 15 pages. Now it's 16. How long before we get to 17? I bought my condo. I love this story. I bought my condo in 2006. So what was that? 16 years ago, give or take? When I bought my condo in 2006, the offer to purchase and contract was 8 pages. We've doubled it in 16 years. Ain't that something? No end in sight. Questions or comments on our standard offer to purchase and contract? You will have test questions on this. Okay, Jory, that wasn't necessary. Thank you for sharing. Let me ask you guys, if this is this the first time you sat down and looked at this thing? I mean, we did a pretty thorough review, I would say, word for word. Is this the first time? It's okay. If it is, that's why 302 is here. Is this the first time you sat down and looked at this thing? Yeah. I hope it's not the last time you sit down and look at this thing.
Oh, I take that back. No, ma'am. But
You've seen
remember,
it
I told
before?
you I didn't do it well on self-pace.
That's right. That's right. That's right. So this is the first time you've seen it that you get it now, right? Good.
Yes, ma'am. And thank God,
Good.
thank God for you. Thank God.
Thank you. I can't imagine self-paced. Yeah, that's a different. Again, you guys, I hope this isn't your last time going through it. When they update this form, the forms committee is really, well, any form, let me go back. Any form provided by NCAR, the North Carolina Association of Realtors, I love what they do. They give us a markup. So they will take an old and go through and highlight what's new, cross out what's been removed. So in other words, when they update our form, we don't have to sit there and do a side by side and look for what's different. They provide us a markup so we can easily see. They also give us a summary of the changes. Hopefully when they update our forms, that's part of your training of your firm. They'll have a big sales meeting. They might even bring breakfast in, and we're going to have let's talk about the form updates to make sure that not only do you have the most recent form in your hand, in your possession, but also you're aware of those changes and how it applies today. You can't do things the way that you did 2 years ago if it's been removed from the form. So we need to be, constantly making sure. Back in the day when I did sales, before I taught, when I did sales, I made it a conscious effort to sit down and read this thing every time they updated. So not only did I look at the markup and the changes, but I figured that was a good time for me to sit down and read it. And I'll tell you why. Our part of it, all we're allowed to do is fill in the blanks, right? So wherever you see a blank, that's all I'm allowed to do. So with the exception of page 1, our part of it is really pretty small, isn't it? We don't have many blanks to fill in. And I fear what happens is we get busy and we only focus on the blanks because that's our job. And if we're not going back and reviewing the whole thing periodically, we forget about the non-blank stuff. Does that make sense? So if we are up to date on the form changes, again, let your firm help you with that. But if we're up to date with those form changes and we're making an effort to sit down and read this thing every once in a while, that's the best service we can offer our clients. Same thing with the listing agreements. I made it a point, I would print them all out. That's when I would go to Starbucks or something, but just make myself sit there and just go through it. So I was familiar with it, so I could best represent my clients. We're getting back into a market where we're going to have to do open houses again. Some open houses, you're going to see lots of people. Some open houses, you're going to go 2 hours without seeing a soul. What do you do with that long afternoon? take your forms, read them, make it a productive afternoon one way or another. Comments? Just as a reminder, let's get in Learn Test Pass. Just as a reminder, under the forms category, and then you have link to forms, so then you're here. I did not include, I'm not going to pull these up, but just as a reminder, with the offer to purchase included with that is the guideline, no, is the guidelines for completing the offer to purchase and contract. 2G is the guidelines for completing. So if you want to know what the commissions or the NCAR stance is, what they expect, you can tell you, it kind of walks you through what goes in terms and definitions, what goes in the purchase price, what goes in, you see, it kind of helps us better understand the various provisions of the contract. The contract itself reminds us to use the guidelines 2G. So it references back to those guidelines as well. For those of you with a firm, you have access to this through your firm's files, .loop, SkySlope, whatever you use. If you're not with a firm yet and you want this, you got it. It's available right now. So if you want to grab it before class is over, again, it's just in Learn Test Pass under that file. What am I trying to say? Forms section, forms chapter there, and you can just click on that link. It's a good tool, a good resource to have to make sure we're completing it properly. As mentioned last week, we also have an offer to purchase and contract for vacant lot and land. Again, this also has guidelines for completing. So if you've never done one of these before, if you've never completed one of these before, it references you to Form 12G. We're not going to go through this one in the detail. Good news that we did the other one. But I do just want to point out a few things. Starting on page 1 with the blue notes. For vacant lot and land, we are told, vacant lot and land, if the seller is selling less than the entire parcel of land owned, then compliance with the subdivision regulation and or adequate legal description of the land sold must be considered. This contract should not be used to sell property by reference to, exhibition of, or any other use of a plat, shown a subdivision of the property before the plat has been properly approved and recorded with the Register of Deeds. If a preliminary plat has been approved, this contract may be used, and if an addendum drafted by an attorney addresses certain statutory requirements is attached. The general statute tells us for more information and possible explanations. If the buyer is contemplating a subdivision as land, a condition of purchase, buyers should first consult with an attorney. Our blue note for new construction. If seller is buyer's builder or has engaged a builder and the sale involves the construction of a new single family dwelling, then we're told to use the offer to purchase and contract for new construction that we'll look at next. Or Form T with the new construction addendum. Again, we will look at that addenda in just a second. So making sure we're using the right form, I'm assuming that goes without saying, making sure we're using the right contract form. When we can and cannot, should or should not use the vacant lot and land is addressed in this, in the first couple notes. You can see terms and definitions. We're going to identify the parties, buyer, seller, property. That purchase price is very similar to what we saw. How is that going to be divvied up? Due diligence, earnest money. You know, one of the big things missing from the escrow agent effective date, one of the big things missing from lot and land is we don't have a structure to inspect, right? We're standing on a hunk of dirt. We don't have a structure as part of the sale. It's just dirt. So a lot of that verbiage about the structure, the property itself, we're not going to have in here. Buyer still gets a due diligence. That piece is not changed. If buyer has to get a loan, property investigations look a little bit different, again, because we know we don't have a structure to inspect. So now we could be looking at soil and environmental, sewer and septic, water. Especially if it's unimproved, like how are we going to get water to the structure? Does the structure need to be located in a certain place to allow for public water and sewer if we can? If it's on-site sewer, then we want to have perk tests, get an improvement permit. So all that's addressed there. Closing shall constitute acceptance of the property in its then existing conditions. Buyer has to represent to the seller still how they're going to purchase. A lot of this is the same. Buyer's obligations, their responsibilities, seller representation. Again, under here, seller has to represent sewage system permit, applicable or not applicable. Private drinking water well permit, applicable or not applicable. More land stuff than building stuff. Owners Association, da 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 da. This one's only 13 pages. Remedies paragraph, spelling out both. Buyer, seller, sign. So that, yes, ma'am.
Something that said the conduct of something. Do we have, no, not conduct, go up a little bit more. The conduct of transaction, do we have that on the other contract?
Yep, sure do. This is given consent for electronic means, telling us the notice information is how we want to be communicated. I'm going to call this, with the exception of the remedies, I'm going to call this last page pretty much boilerplate, which means you're going to see it in most contract, just standard contract verbiage. Okay. So 12T, again, if you're a numbers person, you don't need to know the number, but sometimes it helps knowing the number. So 12T is our offer to purchase and contract for vacant lot and land. The other contract we have that we're going to talk about is 800T. This is offer to purchase and contract for new construction. Once again, 800T comes with guidelines for completing. So if you've never done a new construction contract before, it's suggested that you take out the guidelines to make sure that you're completing it properly for your clients. I don't know why this isn't a blue note or a red warning, but it's in bold and it's right at the top. So I think it's still worth paying attention for. This form is designed for use when the seller of a new home is or has engaged a licensed contractor who is constructing or will construct a spec or custom single-family dwelling on land owned or to be owned by the seller, and then conveyed improved land to the buyer. It is not for use when the seller does not or will not own the land to be conveyed. Buyer owns the land, or buyer will provide financing for construction. So again, it starts out, if you're not sure use this form or not, but this and the vacant lot and land start with instructions on when we should or should not use this. Remember, you also have the guidelines, you have your book, your manual, you have your BIC, you have other resources to make sure that you're doing that. One of the big things that this one addresses, there's now construction verbiage in here as well. So pre-construction evaluation period has a date on it. When do we expect to have that done? Plans and specifications. We're looking for site plans, floorings, floor plans, landscape, etc. So we're looking for that information. Building deposit needs to get brought up. How the installment payments are going to be made. Part of the building deposits, how they should be. Maybe each phase of construction, there's a different building deposit that the builder expects to collect, or maybe even how that's going to be paid. It might be a date or triggering event for the payment. So we got to agree on, does that make sense? Each phase, we got to get more money. And so we got to agree on when and how much at each phase of construction. Conditions applicable during pre-construction evaluation period. How the loan is going to be issued. Some lenders for new construction don't issue the whole loan all at once. They may do it in installments. So they may, you know, kind of with each phase of construction, they may break that down as well. Various reports, soil suitability, utilities, environmentals, things that we don't have to deal with, septic, private drinking water, insurance on the properties is being built. Street disclosure, again, I'll let you guys look at this.
Do the builders ever have their own version of their own contracts?
It's not uncommon for a builder to have their own. This one, it's awfully wordy, isn't it? This one's also 16 pages. I see builder contracts that are like 3 or 4. Now they have exhibits and addend, right? They have, you know, other things attached to it, but which is going to include, you know, probably some of this stuff, you know, that we see in the contract. But instead of using this particular form, yes, it's not uncommon for a builder to have their own contract. And I think we see that. I see that a lot more than this being used.
So the builder's contract supersedes this one?
That's the contract that the parties use. Yep. Yep. Whatever contracts the parties agree to. Yep. We're going to use this one pretty much, Patricia, if the builder doesn't have their own. We need something then. There's implied warranties for the builders. So, you know, this contract, there might be reasons why to use this one because it does cover a lot more than some of the other ones I've seen. So it addresses those implied warranties that builders have. What's the R value of the insulation? Buyer still has to represent various things. You'll notice there's no RPOs. That's not required for new construction. So all we're going to have is a MOG. The builder has to disclose if they have severed or if they intend to sever the subsurface rights. I do want to make sure there's nothing else that just kind of pops out at me. Yeah. Please note, you guys, and we're going to look at this next. This is where it gets confusing. I have an offer to purchase and contract for new construction. I also have a new construction addendum. So we have an offer to purchase and contract for new construction. And then I have a new construction addendum that attaches to 2T. Now we'll look at this note in a second. So the question is, what do I use? Do I use the contract for new construction, or do I use standard form 2T with the new construction addendum? And the answer is, it depends on how far along in construction we are. If it's construction hasn't started, or if there's still substantially a lot left to do, maybe we're just standing amongst studs, we need to use the offer to purchase and contract new construction. If it's complete or almost complete, now we're using 2T with the new construction addendum. Everybody see that? So which one you use depends. This tells us the new construction addendum, this is for when construction is complete. It's still new construction. It just depends on the phase. Is it done or almost done? Our new construction addendum says this form is designated for use when seller is a licensed contractor or has engaged a licensed contractor who has completed construction of spec dwelling, including a townhouse but not a condo, on a property owned or to be owned by the seller, who will convey improved property and should be attached as an addendum to standard form 2D. It may not be used when the seller or contract may make additional minor repairs to complete a dwelling. If construction is not complete, or if extensive additional improvements are to be made, the parties then should use 800T instead of this form. So I have an offer to purchase and contract for new construction. And then we have a new construction addendum to attach to Form T. Isn't that confusing? Again, which one do you use? The forms tell us. The forms tell us. If you still have a lot left to go, don't use this one. Use the offer to purchase and contract. New construction. Y'all remember that one very important sentence in standard Form 2T that says the property is being sold in its current condition. So if you use the wrong form, you have new construction, you're just standing amongst some sheetrock and some, some studs, and you use the wrong form, and the builder's not represented, it's a shady builder, and they sign it, they're done building, aren't they? Because everybody signed something that says this property is being sold in its current condition. So either use an offer to purchase and contract new construction, or using this one with 2T will make the builder keep building. Does everybody understand? This happened to my team. We were working with a builder. Agent presented an offer on standard Form 2T. No new construction addenda. Luckily, one, the builder's a good guy. He wouldn't have done it anyway. But two, he is represented by real estate agents. And we have a duty to treat the other party fairly and honestly. We called that agent and said, you need to do this on a new form. You about hurt your clients. Because if our builder had signed it, let's pack it up and get out, boys. We are done. Please make sure you're using the right form. When in doubt, find out. Boy, was that a learning lesson, wasn't it? I hope for that other agent. I hope. So now we got the addenda that's attached to 2T. We got to identify who the general contractor is. Here's that limited warranty liability that we saw in the new construction offer, but we don't have it in 2T. So there's that limited warranty. Insulation, da-da-da. This is probably the most important piece. If there's anything left to be done, let's spell it out. Let's go ahead and say the builder needs to do, maybe the builder just needs to do their final punch list. Maybe they just need to, I don't know, put screens on the one, right? We're almost done. We just have 2 or 3 little things left to do. That's what we need to make sure that we identify for our buyers to make sure that it gets done. Inspections, buyers are always encouraged to have inspections done, even if it's new construction. Humans build these things, you guys, and humans make mistakes. There's no such thing as a perfect house. Even a brand new construction, there's going to be problems with it. So even if your buyers buy new construction, can't hurt them to have a home inspection done. Obviously, this form has to address the building deposit. Everybody signs, including the general contractor. General contractor has to sign as well. Same thing on 800T. We're going to identify the contractor and then, yep, they get to sign it. They get to sign for the sole and limited purpose of agreeing to remain jointly and severally liable with the seller for the warranty obligations. So they're signing for the warranty. They're not a party to the contract. They're signing for that implied warranty. And then acknowledgements of receipts of building deposits. Questions on these two, the difference of the two, when we might use the two. The addenda attaches to 2T. If you still have a lot to go, then you have a standalone offer to purchase and contract new construction. Questions or comments on that? All right, let's see what other good forms we have up here. We did that one. FHA VA financing addendum. By the way, we're just going to look at a few more and then we'll go to lunch. And then after lunch, we'll look at the rest of the forms. I told y'all today was forms day. So I hope you came in the form mind because that's where we are most of the day. FHA VA financing addendum. We're going to use this, attach it to the offer to purchase and contract when our buyers are getting an FHA or a VA loan. So remember, the contract reminds us to use this addenda. And it's broken down into two sections, one for an FHA financing, the other for VA financing. So FHA has an amendatory clause. It's expressly agreed, notwithstanding any other provisions of this contract, or the purchaser shall not be obligated to complete the purchase of the property or incur any penalty for forfeiture of earnest money deposits or otherwise, unless the purchaser has been given in accordance with HUD or FHA, a written statement issued by the Federal Housing Commissioner, the Department of Affairs, setting forth the appraised value of the property of not less than, and then we're going to put an amount in there. So basically what we're saying, and usually the amount we see in there is the purchase price, but the parties can agree, like in this market, they may have a little bit more, for example, because we know it's, or less, because we know it's going to appraise for what it closes for. But we're going to need to put an amount in there. And what we're saying is if it doesn't appraise for this amount, the buyer can terminate, get their earnest money back. We're going to protect their earnest money. The purchaser shall have the privilege and option of proceeding with the consummation without regard to the appraised value. So if the home doesn't appraise, they don't have to terminate, but they have the option, they have the choice. The appraised valuation is arrived to determine the maximum mortgage of the Department of Housing and Urban Development. HUD does not warrant the value nor the condition of the property. Purchasers should satisfy themselves that the price and condition of the property are acceptable. FHA and VA, as we're getting ready to see in just a second, aren't popular loan types right now. Again, there's 20 people standing in the front yard with an offer in their hand. And if one of them has an addendum that says if it doesn't appraise, I don't have to proceed with the purchase. So sellers aren't seeing this as a positive right now, understandably. You know, they want to know that their buyer's going to buy. But as that pendulum swings back, I think we're going to start seeing this become, I'm not saying no sellers accept FHA. I'm just saying they've definitely lost popularity in this crazy market that we're in. So we're protecting their earnest money if it doesn't appraise. If it's a VA buyer, it's expressly agreed that the buyer shall not incur any penalty or forfeiture of earnest money if the contract price or cost exceeds the reasonable value of the property established by the Department of Veteran Affairs. So same verbiage, we just don't have to put a price in this time. We're just saying, look, if it doesn't appraise for the purchase price, the buyer shall, however, have the privilege and option of proceeding without regard to the amount of reasonable value. If buyer elects to complete the purchase in the amount of excess the reasonable value, buyer shall pay such excessive amount in cash from a source buyer agrees to disclose the DVA, which buyer represents will not be from borrowed funds except approved by the DVA. So if the home doesn't appraise and the buyer's got to come up with money out of their pocket, what this is saying is you can't get another loan. You got to have this money cash unless you get approval. Guys, that does include a loan source from a private source, a loan from a private source. So for example, the bank of mom and dad. I cannot borrow money from the bank of mom and dad. Now, could mom and dad gift the money? Sure. You know what the difference is in a gift and borrowed? When you pay back, the other one you don't. So if mom and dad are going to gift the money, the lender will probably make them sign something saying, this is a gift and I don't expect to be paid back. And if mom and dad lie, that's called loan fraud. So you could take them, they could go down as well. If reasonable value is less than the sales price, seller shall have the option of reducing the sales price to equal amount of the reasonable value, and the parties that may close at such lower price. Again, we can, if it doesn't appraise, we can always ask the seller to reduce the price. Do they have to, or are they under any obligation to reduce the purchase price? No, we already got a contract saying we agreed to this amount, right? So we can ask the seller, but they don't have to. The second paragraph of the VA we were talking about earlier, the DVA may or may not require well, water, septic, sewer, or wood destroying insect inspections to be performed. If such inspections are required to be performed, they may or may not be required to be at the seller's expense. So listing agents, if you get one of these in and your seller's considering a VA offer, they need to know they're going to be on the hook, may be on the hook for paying these expenses. If they are performed and required to be at the seller's expenses, seller agrees to pay the cost of the inspections. So listing agents, again, when we start seeing this come back, FHA and VA loans, particularly with VA loans, we just need to have this conversation with them. Let them know that $70 pest inspection, that could come out of your closing costs. Anytime we have a conflict between an addendum and the contract, the addendum is going to control. So this is verbiage we see in all of our addenda. If one differs than the other, whatever we have in the addenda is going to be the one to control. Real estate certification. The seller, the purchaser, and the broker hereby certify that the terms of the sales contract are true to the best of their knowledge and believe, and it is agreed that any other agreement entered into the parties is fully disclosed and attached to the sales contract. The seller, the purchaser, and the broker fully understand that it is the federal crime punishable by fine or imprisonment or both to knowingly make any false statement concerning any of the above facts is applicable under the provisions of this title. One thing that's very unique about this form, buyer signs on the left, seller signs on the right, hereby read and understood the above statements. But guess what, y'all? This is a rare form that we get to sign it too, because we're acknowledging and understanding that certification that we just read. We don't get to sign much, but this is one we do get to sign, and this is what we're signing. This is what we're signing for. To the best of their knowledge is agreed on it, entered into the parties, fully disclosed and attached to this contract. It's a federal crime punishable by law to both knowingly make any false statement concerning any of the facts above. And this is an addendum. So it's going to attach to and become part of our offer to purchase and contract. In other words, as a buyer's agent, when you're presenting the offer, included in the offer is going to be this addenda with your pre-approval, pre-qualification letter as well. Questions on FHA VA financing addendum? Okay. Y'all about ready for some lunch? I think we're ready for some lunch. All right, let's take lunch. Let's see. I just now got 12:30. So let's take 50, 12:30. Let's come back at 1:20. Is that 50 minutes? Yeah, we'll come back at 1:20. So as before, I'll log on, 1:15. You guys are free to come back and we'll start class back up at 1:20. Everybody good? All right, go enjoy your lunch. Go outside. It looks really nice outside. Yes.